The meeting of the General Laws and Technology Committee will come to order. Clerk, could you call the roll? Set things up.
Mr. Chairman, could I be counted as present? I've had some courts, so I don't have one to. Oh, I understand. This is okay. You want to leave a copy? Yes, I would.
All right. All right, we have one measure to refer to a different committee. That's Senate Joint Resolution 322 from Senator DeSteff, and it deals with the study of a potential for having military overseas voters be able to vote electronically. And so we will refer that to the Privileges and Election Committee. We refer. Motion from Senator McPike and second by Senator Reeves. Any discussion? All in favor, vote aye on the board. So.
Senator Stewart votes aye. Thank you.
All right.
Ayes 14, no 0.
Who do we have waiting outside to present bills?
You've got Senator Newman, Cosgrove, and is that Chase? Cosgrove, Newman, Chase, and Boysko.
Okay. Well, we'll deal with Boy School later because she's going to be back and forth between here and the other.
You want Newman?
In the order of the agenda, I think we went through first.
Yeah. All right. Come on in, Senator Newman. All right, proceed, Senator Newman.
Yes, thank you, Mr. Chairman. Mr. Chairman, this is Senate Bill 1349, and all of our friend Senator Chafin had introduced this bill, and I've agreed to carry it for him. Mr. Chairman, this is brought to us also by the Independent Insurance Agents of Virginia. It allows licensing agents to include the email address and information distributed about their licensees, but it can only go to persons or businesses offering professional education services or courses, continuing education, CE. Currently, there's allowed to be distributed the person's name and mailing address, and what they must then do is they must mail the individual the request to receive the continuing education. This would say that the person's email address would be kept also, and this, in their opinion, would be saving paper, saving mailing cost, and also allow people to know about CE on a more timely basis. Mr. Chairman, that basically is the bill. You will see that it inserts it inside the section which is 5, which is the maintenance of lists.
All right, are there any questions for the patron? All right. Do we have anybody who wishes to speak on this measure?
Mr. Chairman, Senator Reeves.
Senator Reeves.
I appreciate Senator Newman bringing this bill on behalf of Senator Chafin as somebody who is licensed in insurance and financial services. Trying to keep up with CE credits is a nightmare. I hear that from my licensed attorneys also, but I think it's a great bill, and I'd move the bill forward.
Do we have anyone to testify?
Yes, Mr. Chair, I believe we have one. Robert Bradshaw, please unmute yourself.
Okay. Mr. Bradshaw.
Yes, thank you, sir. And I think I was told a long time ago that the more you speak, the more people can come up with ideas to vote against your position. I thought Senator Reeves hit the nail on the head, and that's what we're trying to do in a more efficient way to contact licensees about continuing education opportunities. If you have any questions, I'd be happy to answer them.
All right. Any questions for the presenter? All right. We have a motion and a second to report the bill. Do you have a list of ones that need to go to finance? Is this one? 1349. Okay. All right. Well, we have a motion to report the bill. And unless there's any discussion, we will vote now.
Ayes 14, noes 0.
All right. Thank you.
Mr. Chairman, I had the other bill, but I understand what your thoughts are on that bill, and if you don't mind, I'll just leave that in the well of the body, if that's okay with you. Okay.
All right. That sounds fine.
Thank you for your kindness. Thank you.
Certainly. All right. Senator Cosgrove, I guess? I'll tell him. Okay. Yes. Thank you. Certainly.
Mr. Chairman, today before your committee, I have Senate Bill 1424.
Okay.
1424 basically defines a manager of record as a person who manages and handles all the operations of a licensed funeral service establishment and sets out to the conditions under which funeral service licensees or a funeral director may serve as a manager of record. The bill requires that funeral service establishments employ a full-time manager of record. So, Mr. Chairman, that's pretty much it. Right now in Virginia, we have 3 separate methods of education. One is for funeral directors, one is for embalmers, and one is for funeral establishments.
Mr. Chairman?
Yes.
Senator Reeves, Senator Cosgrove.
Yes, sir.
I think we started to hear this bill. You saw that there was some rumblings and you were trying to get peace in the valley. Is there peace in the valley on this now?
Mr. Chairman, Senator Reeves, I'm not sure. I do know that all 3 major funeral home organizations are in support of this piece of legislation. I believe there may be one company that may be in opposition.
Thank you, Senator.
All right. Are there any, is the bill still in the form that it was introduced?
Yes, Mr. Well, actually, there is I believe staff has a couple of amendments.
Mr. Chairman, the amendments were offered and adopted by the committee at the last meeting, so those should appear on LIS.
Okay, great.
Okay.
Yes, sir. Thank you.
Mr. Chairman, I move to report the bill when appropriate.
Do we have anyone to testify either in favor or in opposition?
If you would like to speak in support of the bill, please raise your hand. Scott Johnson, please go ahead. Mr. Johnson? Larry Spiaggi, please go ahead.
Scott Johnson's on the screen here.
Mr. Chairman, it's Scott Johnson. We're opposed to the bill, so I will wait till you call for opposition, please.
Okay.
Larry Spiaggi, please go ahead. please unmute yourself.
Yes.
My name's Larry Spiaggi. I represent the Virginia Funeral Directors Association, which is the largest and oldest association for Virginia funeral homes. What I want to make clear is that a manager of record is responsible for everything that happens within the confines of that building. Even from the prep room to the cleaning staff, everything's responsibility of the manager of record. When embalming occurs at another location and is transported to a branch that isn't technically doing the embalming there, the person that's responsible, the manager of record, is responsible for that body once it's in their building. And if something goes wrong, which does on occasion happen, the body would have to be addressed, be taken out of the casket, fixed, put back in the casket. That's the reason behind the wording of this bill. A funeral service licensee is qualified as an embalmer and a funeral director. The funeral director only is qualified to be a funeral director. They have a little bit of knowledge. We've tried to put some education into it to make sure that they're going to have some knowledge. The people that we saw originally that were opposed, I'm not speaking for Scott Johnson, there was some wording problems, and we fixed that. Y'all have amended it, and you have fixed it. We had prior instead of after, and that's been taken care of. And people talk about public safety and health safety. One of the things that I think you as legislators should be very proud of is that within the Commonwealth of Virginia during this pandemic, because all of the funeral homes have licensed embalmers, funeral directors in their buildings, there was not one traced back super spreader event or a breakout of COVID during this whole time we've been fighting this. And that goes to reflect on the training that the embalmers have concerning microbiology and disease and things along that line. That's why we feel this is important. If an establishment is going to have embalming, that there should be an embalmer to be the manager of record or funeral service licensee. That's the important part for us. The other thing is you need to understand that all funeral homes don't embalm. There are establishments. I have two companies. One is a company that does full traditional funerals. The other is just a cremation company. That company would not fall under this because we do not offer embalming. We do not embalm bodies. We do not have a charge for embalming on our bill. And if one of them, the mosque, want to open up a funeral home and take care of their own dead, they would also fall under this exemption. They would not be mandated to have an embalmer on staff to run that funeral home. Thank you very much.
Those testifying in opposition. Scott Johnson, I guess you were up first. You were called earlier. Is there anybody else? Okay.
Yes, sir, Mr. Chairman. Thank you. This is Scott Johnson. We represent SCI Funerals of Virginia. We have approximately 50 plus facilities and cemeteries around the state, and we appreciate your time. We're very much opposed to this bill. If you remember last session, Senator McPike introduced legislation directing the Board of Funeral Directors to create the regulations to have the funeral director only license. So now we would have 3 again in Virginia. We used to have 3. They were convinced some years ago. This is not a bill the Funeral Director Board is asked for. Instead, this is a bill the associations have asked for, and this bill will greatly handcuff the good work you did in passing Senator McPike's bill last year out of general laws unanimously, because it will limit who can serve as a manager of record. It basically says if you're a funeral director, if your facility does embalming, you can't be a manager of record. It would also say if you even have a price list saying where some other place has embalming and what the price is, you can't serve. That doesn't make any sense. That's trying to protect cronyism in old Virginia. The legislation you passed last year was to create jobs. It was to give flexibility for the various religious faiths. This legislation has taken us back It's an attempt to restrict competition, and that's why you heard from the Virginia Consumer Alliance, the Funeral Consumer Alliance. You have letters from that, and some of you have probably also heard from Americans for Prosperity. We would ask that you PBI this legislation, and I'm glad to answer any questions.
All right, are there any questions? All right, is there anybody else to testify? All right, the floor is open. Any comments or motions?
Mr. Chairman, I would make the motion to report the bill.
All right, we have a motion to report. Is there a
Mr.
second?
Chairman, substitute motion.
All right, well, did we have a second on that first motion?
Substitute motion.
Your motion dies for lack of a second. Was there a second?
Substitute motion to PBI.
Or Hashmi?
Sorry, Mr. Chair, substitute motion to PBI.
We have a motion to pass by indefinitely. Is there a second for that? Second. All right. Is there any discussion? All right. We will then vote on the board.
Senator Vogel, how do you vote?
Senator Vogel votes no.
All right.
Ayes 12, noes 3.
Thank you, Mr. Chairman.
12 no, 3. Thank you. And your other bill?
Yes, I'm sorry. The other bill I have here today dealing with solar power, I'd like to strike it.
All right. The other bill he wants to have stricken. Is there a motion to strike the bill? All right. All right. Motion and a second. Any discussion? We'll vote on the bill.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
Ayes 15, noes 0.
All right. Thank you. All right, you're up. Senator Sarabel.
Thank you, Mr. Chairman. Senate Bill 1384. Let me pull up my talking points here. Senate Bill 1384, you might remember from last year. This is a little bit of a different spin on a bill that you all heard before. So, let's see. Where did I do it? So 1384 has to do with arbitration agreements. So let me start with this. Today, when a company wants to do business, when a locality wants to do business with a company, and they want to do a procurement, and they want to check on the background of the company's history, they can look around in the public record to try and figure out what's out there. They can see if the company's been sued, if they've had consumers sue it, if they've sued consumers, if they've had problems with their employees, sexual harassment, racial discrimination, all that stuff. It's all that. They're part of the public record. The problem is a lot of companies are now starting to use forced arbitration to basically take consumers and employees out of court and hide it from the public record. And you can't see it. There's absolutely nowhere to see it. 2014, the federal government promulgated an executive order that basically prohibited any company seeking to procure goods or services from the federal government, prohibit them from using pre-dispute arbitration clauses in either any of their consumer contracts or any of their employment contracts. So for those of you who live in Northern Virginia, you might remember Congressman Beyer. He used to use arbitration clauses in his contracts with his customers when they bought cars from his dealership. When this was brought to his attention, he immediately stopped doing it. There's now an act pending in Congress, been co-sponsored by every Democratic member of the Virginia delegation, prohibiting this practice, and by U.S. Senator Tim Kaine. Congressman Morgan Griffith has even co-sponsored a more narrow piece of legislation prohibiting arbitration clauses in connection with sexual harassment and employment claims. So this is a bipartisan issue. And basically what this bill does is it seeks to sort of parallel that 2014 executive order that the federal government adopted. So basically what the bill does, first of all, it only applies to it basically requires a locality to have the option. It doesn't require a locality to do anything. It gives all of our localities in the state the option to request information about arbitrated claims involving either consumers or employees. It excludes senior executives, and it excludes any employees that are covered by a collective bargaining agreement, because presumably they have a labor union that can step in and argue for them. So this is about employees that don't have a labor union, and it's not about senior executives. It also only applies to procurement over $10,000. And basically what the bill does is it requires, if a locality chooses to do so in connection with the procurement, the locality can require a company submitting a bid to show their pre-dispute arbitration clause, their boilerplate, the number of times that they have compelled arbitration in the last 5 years involving either employment claims or consumer disputes, the number of employees or consumers that have opted out of arbitration, if that's an option, and the number of times that a claimant prevailed. That is, the number of times that somebody who's seeking to do business with the government, the number of times that a consumer's prevailed against them, or the number of times an employee has prevailed against them because of, for example, sexual harassment, racial discrimination, wage theft, things like that. And it basically says that this claim history can be considered in the procurement process in determining whether or not the government wants to do business with this business. It requires them to update their submissions every 6 months. It says a locality can terminate a contract based on the submission they get if they get an update they don't like, and it's a local option bill. So basically, again, this bill is about transparency. It's about making sure our local governments have complete information before they decide to do business with a company, and it keeps companies that want to get public taxpayer dollars from being able to hide bad business practices or sexual harassment, wage theft, racial discrimination claims. That's basically what it does, Mr. Chairman. And we passed a similar bill, which was much broader last year, out of this body. These problems that I fixed with it were basically related to the issues that were raised on the other side. So I'm hoping that the bill will pass this year. I know there's a lot of people that want to speak to it online.
Mr. Chairman? Yeah, Mr. Chairman?
Yes.
Just to be clear, this is entirely permissive. The local government can choose whether or not they want to do this with their own contracts.
It's 100% local option.
Okay, and to follow up, are there arbitration requirements if there were some kind of secrecy involved in employment in the actual arbitration, the result of the arbitration? They just have to report that it happened, or do they have to get into the results of racial discrimination and otherwise?
I think they have to report that an arbitration occurred and that the claimant was successful.
Thank you.
All right. Are there any other questions of the patron?
Mr. Chairman?
Yes, Senator Hashmi.
Thank you, Mr. Chairman. And Senator, I was just hoping you could clarify the issue of declaring the contractor ineligible within the locality for up to 5 years. Is it specific just to the locality in which there was a violation? And what was the reasoning for this length of time, 5 years, for making them ineligible?
I think the idea is to create the incentive on behalf of companies to comply with the requirements of the contract. I think at the federal level, in the 2014 executive order that was promulgated, it actually created what they called a blacklist, whereas if companies participated in these practices, they weren't even allowed to submit a bid. So this is even more permissive than what the federal government did, I believe. There's some other people on the line that might be able to fill in on that. But I would also, by the way, just note that Congress exercised its legislative veto right, I guess, over the federal prerogative in 2017. After there was a change in control, they passed a law that basically got rid of what the Obama administration had sought to do in 2014. But so that, I think I've answered your question.
Well, my first question was, is if they are placed on some kind of a blacklist, then is it just specific to that locality in which
Yes.
there was a violation, not
Yes.
no other locality?
Only that locality. It says for further, on line 98, it says for further contracts with such locality for up to 5 years. So it only applies to that locality.
All right. Are there any more questions or discussion? All right. Who do we have? Let's do 5 minutes on this bill. If there are a large number of speakers, let's start with the people who are supporting the bill.
If you're in support of the bill, please raise your hand. Chris Nolan, please go ahead. Chris Nolan?
He's opposed.
Sorry, he's opposed. Okay.
Julie Stranley.
Julie Stranley, and just a reminder, if you're in support of the bill, please raise your hand. Julie?
Julie Stranley.
Hi, good afternoon. Thank you, Chairman Barker and committee members. Just to clarify on the Safe Workplace, that was an executive order implemented by President Obama. It was rescinded in January 2017. It will likely have a good chance of being restored in the coming months. Thank you again. As Senator Sorrell had mentioned, this bill has gone through many iterations. We had the opportunity to come back this year with refined language. We worked with the Procurement Officers Association. We listened to business concerns, and we talked to legislators going forward. This bill has been very much streamlined, as Senator Sorrell was mentioning. Last year's bill had 19 detailed questions. This year's bill simply asks the contractor if they use forced arbitration against an employee or consumer. The answer is no, that's the end. If it is yes, there's 4 data questions, as Senator Sorrell mentioned. This is very important because, as he mentioned, that the information is hidden. Normally, contractors have the opportunity to and requirement to discuss vulnerabilities, liabilities, pending lawsuits, and in their RFP responses. However, that is hidden for forced arbitration. And just to keep things short, one of the areas where forced arbitration is particularly a problem is protecting where our National Guard members who are on deployment, they are unable to secure their federally protected rights. You may have seen our service members on the Hill and our Fairfax County teacher. So we will hear hopefully later from the Reserve Officers Association, who will testify as to what the impact is of forced arbitration. Our coalition consists of the Virginia Poverty Law Center, the Virginia Employment Lawyers Association, the National Women's Law Center, the National Association of Consumer Advocates, the National Employment Law Project, and today the Reserve Officers Association joined our coalition. And I will turn it over to my colleagues in the length of time. Thank you.
All right. Who's next?
Palmore?
Jeff Palmore.
I'm opposed.
Opposed, okay.
Hugh Baran, please go ahead.
Thank you, Chairman Barker and members of the committee. My name is Hugh Barron. I'm a staff attorney at the National Employment Law Project. We're a nonprofit, nonpartisan research and advocacy organization specializing in a range of employment policy issues. NELP testifies today in support of SB 1384. Forced arbitration requirements deny workers the right to go before a judge and jury when their employer breaks the law. Making matters worse, class action waivers incorporated into these requirements prevent employees from banding together to challenge employer lawbreaking. A recent NELP report showed that in 2019, forced arbitration enabled employers to steal $12.6 billion in wages from over 6 million low-paid workers. Relying on that methodology, we find that forced arbitration enabled employers in Virginia to steal $296 million in wages from low-paid private sector workers in the Commonwealth. In addition to facilitating wage theft, forced arbitration is also used to cover up cases of sexual harassment, racial discrimination, and other employment law violations. SB 1384 gives localities the ability to require bidders to disclose information regarding the use of forced arbitration, but it does not require any locality to seek such information. SB 1384 advances localities' interests in the efficient procurement of needed goods and services because these disclosures allow the locality to determine bidder responsibility. A business's record of compliance with workplace laws, as Senator Searleville noted, and particularly its record of complying with wage payment laws, is an important and appropriate criteria for determining a bidder's responsibility. But forced arbitration obscures evidence of noncompliance because arbitrations are generally conducted in secret and behind closed doors, and there's no public record, as Senator Searleville noted. With the disclosures required by SB 1384, the localities will have a more complete and accurate picture of the bidder's compliance with workplace laws. That will empower localities to make responsible contracting decisions, including by avoiding bidders who may be covering up cases of wage theft, sexual harassment, racial discrimination, and more. Thank you for the opportunity to testify, and I'm happy to answer any questions you may have.
All right, any questions? Is there anyone else to speak in support of the bill?
Yes, Mr. Chair, we have two.
What's that?
We have two, Mr. Chair.
Okay.
Andrea Johnson.
Good afternoon, Chair and committee members. Andrea Johnson with the National Women's Law Center in support of the legislation. This is a really important issue for us because forced arbitration is too often used as a tool to cover up sexual harassment and violence in the workplace and other forms of discrimination and prevent survivors from seeking justice and being made whole for their injury. In arbitration, survivor stories remain secret. And they are often forbidden by non-disclosure clauses from sharing their experiences. The Virginia legislature has already recognized the importance of not silencing survivors by passing legislation in 2019 to prohibit employers from using NDAs and employment contracts to silence survivors of sexual assault. This bill is also an incredibly important measure to ensure justice. It doesn't prohibit the use of forced arbitration, but we think it takes a really important step towards ending the use of forced arbitration by increasing transparency.
All right, thank you very much for your testimony. You got one more? We got one more, and just quickly give us your name and your position on the bill.
Carla Gilbride, please go ahead.
My name is Carla Gilbride. I'm a senior attorney with Public Justice in Washington, D.C. I speak in support of SB 1384 because while these contractual provisions remain legal in the United States and are treated as consensual agreements, in reality, they are forced upon employees and consumers as matters of adhesion. Many times consumers and workers have no idea that arbitration clauses were included in their onboarding paperwork or in long online terms of use that they had no reasonable opportunity to negotiate or to meaningfully agree to. And by shedding light on the prevalence of these practices, by which businesses are using them, localities within Virginia are empowered to make responsible contracting decisions and to share that information, make that information publicly available that all people in Virginia have more information about these provisions.
All right, thank you very much. Then we'll now take testimony from people who are in opposition. So,
Chris Nolan, you'll be our first speaker. Just a reminder, if you'd like to speak in opposition to the bill, please raise your hand.
and we'll have 5 minutes for those in opposition as well.
Yeah, Mr. Chairman, Chris Nolan with McGraw Woods on behalf of the Associated General Contractors, and we do oppose the bill. There was reference to the executive order by President Obama, and I would just point out a couple of key differences. One, that EO only had a 3-year look back, is my understanding. This bill has 5. And 2, it applied to subcontracts for supplies and materials greater than $500,000, and that were not for commercially available off-the-shelf items. So as a contractor, we may have subcontracts and vendors for whom we buy supplies and materials from. If those vendors also supply to the public, now the contractor is being put in the position of having to know whether the HVAC system company also has a arbitration provision in its contracts with consumers or for employees that are not related to the project on which they are working. So I would direct your attention to lines 89 through 94, and particularly line 91. This puts us on the hook as the general contractor for knowing what our subcontractors and vendors have in their contracts. And now we have to report that to the locality. And if there is a problem with that, the locality can debar us for up to 5 years. And yes, I understand it is discretionary on behalf of the locality, but that is a severe penalty for potentially a problem related to paperwork. I would also point out that this bill puts the contractor in the middle of enforcing the provisions of this act in lines 92 through 94. So if the locality has a problem with a subcontractor, this allows, it's very open-ended, that the contracting agency may direct as a means of enforcing such provisions, including sanctions for noncompliance.
You're down to 3 minutes total for the opposition, so.
Yep, and I have finished up. I just wanted to point out those deficiencies in the bill, Mr. Chairman. Thank you.
All right, next.
Jeff Palmore, please go ahead.
Jeff Palmore.
Good morning, good afternoon, everybody. Jeff Palmore on behalf of the Virginia Chamber of Commerce. It's fundamental in the Virginia Public Procurement Act that the goal of the act is to allow for public bodies to obtain high quality goods and services at a reasonable cost. And this bill would inject really extraneous matters unrelated to the contract that's being considered by the local body into deciding whether the contract is awarded or not. And it should really be based on the best price in getting quality goods and services, and not bring in extraneous items. The arguments from the proponents are
2 minutes total.
Yes, sir. I would also mention that it's our firm belief that this legislation is preempted by the Federal Arbitration Act. The Supreme Court ruled in an opinion written by Justice Kagan that it's illegal for states to explicitly or covertly disfavor arbitration provisions in contracts, and this would covertly disfavor arbitration provisions in contracts. So we think this is preempted by federal law. We hope you'll oppose the bill, and thank you for your time.
All right, next.
Matt Brunning, please go ahead.
Good afternoon, Mr. Chairman, members of the committee. Matt Brunning with Virginia Bankers Association in opposition to the bill. The information the bill seeks to require during a local government procurement process is not something businesses are currently required to collect and report. So this adds additional cost and complexity to doing business in Virginia localities. And in doing so, potential bidders could be discouraged from even submitting in the process, meaning the best goods and services might not be available for citizens or the locality.
You're down
For
to
the
1
reasons
minute.
previously mentioned, we also oppose the bill. Thank you.
All right.
Scott Pedowitz, please go ahead.
Thank you, Mr. Chair, members of the committee. Scott Pedowitz with the Arlington Chamber of Commerce. We also oppose the bill on account of the requirements that's being added here, the fact that it's putting into FOIA the practices of the businesses, and for all the reasons that have been said. Thank you.
All right, 30 seconds. Anybody else?
Yes, Mr. Chair. Clayton Medford.
Clayton Medford.
Hi, Mr. Chairman. Thank you. And on behalf of the Northern Virginia Chamber of Commerce, just want to associate myself with the comments in opposition to this bill. We don't believe that these kinds of terms are valid things to consider when choosing public contracts. So thank you.
Is that it? All right. We are now through public testimony. Any discussion or motion on the bill?
Can I address some of that?
Chairman?
Can I address some of that, Mr. Chairman?
All right.
Unless somebody else has a
Let
question.
me see if there's any deliberation yet first.
Mr. Chairman, this is Senator Vogel from the screen
Senator
far
Vogel,
away.
yes. Yeah. Senator Vogel.
I have a question for the patron. While I'm very sympathetic to the underlying issues that caused him to bring this bill, I have a question about the preemption piece, and I'm wondering if he would be willing to speak to his position on federal preemption. I'm just curious him to respond on that.
Right. So the Federal Arbitration Act, to my knowledge, only prohibits us from doing anything that results in an arbitration provision being unenforceable. So, in other words, we can't pass a law that makes an existing arbitration clause in an existing contract unenforceable. And this doesn't change anything about the enforceability of an arbitration contract at all. It just simply says if you're going to arbitrate with consumers or your employees, you need to disclose that, and you need to tell us how often you've used it and how often you lost an arbitration. Is basically all it says. It's all information. It doesn't make the arbitration provision unenforceable, which is what my understanding of the Arbitration Act, the Federal Arbitration Act, is directed to.
All right. Any other discussion or questions from the committee? All right. Senator Thurwell, you want to wrap up?
Yeah, I'll just say a couple things. I mean, I'm sort of scratching my head a little bit because some of the largest members of the Chamber of Commerce have now stopped using these types of arbitration provisions in their contracts. Google no longer does arbitration with consumers, neither does Wells Fargo or Microsoft. It's because these provisions it doesn't look very good when you're using arbitration to hide sexual harassment or racial discrimination. And it doesn't look good when you're trying to hide that your services have all kinds of problems by burying it in arbitration. And so that's why these things are on the out. So first of all, I think that there's definitely been a change in how businesses are dealing with this going forward. And I know there's some companies that continue to like to cling to this, but it's a disfavored practice. Secondly, I just want to make clear that there is an exclusion in this for parties that have situations that involve people with significant economic power. If you're an employee in an organization that is represented by a labor union that is there to fight for you and fight for your employment contract, and there's arbitration in that, that's excluded from this. If you're a senior executive, you're the CEO, CFO, CIO, COO, these people have highly negotiated, carefully constructed contracts. Those agreements are out of this. This mainly has to do with sort of mainline employees, people that don't have that kind of bargaining power, and consumers who basically just get boilerplate contracts put in front of them when they click a button on a website or they use services. Those are what you heard is typically seen as contracts of adhesion because you can't really negotiate them. And that's what this is addressed to. It's important that if our local governments are going to purchase services from these companies, and these companies have histories of either poor service or they have histories of racial or sexual discrimination, that the locality ought to know that before they agree to enter into their contract, and they ought to be able to consider that variable before they make the procurement decision. And that's basically what this does. It levels the playing field between companies that don't use arbitration and companies that do use arbitration when localities are asked to choose between vendors. And so, Mr. Chairman, I think this is much narrower than the bill last year. As you heard, the bill last year, they had 19 questions they have to answer. This year, it's 5. This year, this is limited solely to consumer disputes and employment disputes, not everything and anything the company does. We really scoped it down big time this time, and I would hope the committee would pass the bill.
All right, is there a motion on the bill?
Chairman?
Yes.
This is a question for the patron. In thinking through the mechanics, and first off, I appreciate the goal because I think there are some real practices that need cleaned up. My question is more of the mechanics. Specific to lines 83 through 94, sort of the ABC section of compliance for post-award actions, can the patron give an example of what, I mean, for instance, if I have a subcontract that I find has a previous action, or I did have an arbitration suit come up in the middle, does that qualify for a violation and a potential termination of the contract? What would be terms that would, under this as written, come up as an enforceable action under the contract?
Mr. Chairman, what I would say to the senator is I believe if they fail to report the number of requests for arbitration, the number of occasions they filed a motion to compel arbitration, the number of employees that have exercised their right to opt out, or their number of times the claimant prevailed, if they fail to disclose that I would think that would be a violation, which would then trigger that provision.
Follow-up question, Mr. Chairman. So under 89 through 91, so every time you have a multiple award contract, for instance, and this now, your previous bill last...
You have a what?
Multiple award, well, okay. So last year, I'll use construction because last year's bill excluded construction. This year's bill does not, so it includes construction. So using that example, I have made an award allowing this as a preference. I'm playing in the locality. Now the contract is let to the contractor. They're doing multiple award buyouts. So at any point in time, they have to substitute a subcontractor. Every single one of them, they've got to figure out all of the information for everyone. What happens if they find a contractor that, because of the specialties, they have arbitration agreements for some reason? I'm just putting out theoretically. Would they be non-compliant with the terms of the contract because they can't find a subcontractor without this sort of precondition applied on it? As read, can the patron help resolve that? Because that's a conflict I can't quite work out yet.
I think the answer to your question is that it would only be a problem if that new subcontractor does not disclose to the general the answers to the 5 questions. But I don't think just by the fact they've substituted a new subcontractor in that happens to use arbitration, that would give the locality the right to cancel the contract. Only give the locality the right to cancel the contract if that new subcontractor said, I'm not answering any of these questions, and they in fact use arbitration. And I would just note also, with regard to last year's bill, the reason we carved out construction was because the construction industry historically uses arbitration for fights at the commercial level between, the contractor and a sub or something, but not, this only deals with arbitration relating to consumers and your own employees. It's a much narrower scope, and that's a different issue than using arbitration to resolve a dispute about the performance of your construction contract.
All right, any other questions?
One follow-up question.
All right.
Just the provision under 72, line 72, 73, in terms of just Freedom of Information Act in relation to all these things. I mean, obviously, it's sort of intentional to, what I understand you're getting at is to sort of expose companies, on if they use them, and therefore, is this going to have a chilling effect on anybody participating? I just don't know across the wide variety of services whether there's a whole sectors that may not participate in bids when basically you're saying all of them are available through FOIA, they're not excluded for every disclosure put in for a public bid.
Well, I would say two responses to that. Number one is, I think without that sentence, there's an uncertainty as to whether or not that information would be otherwise disclosable under FOIA. I would suspect that the bidder might take the position that how many times they've compelled arbitration or how many times they've lost is proprietary, although I'm not really sure I see that. And so we just put this in here to make it clear that it isn't proprietary and it's not excluded from FOIA, because you can get a ton of stuff under FOIA and procurement, a ton of stuff. So that's, I guess, the first thing I would say to that. And the second thing, I can't remember what your other, whether I had something else I wanted to say in response to your question, but.
I think he's let it go, so.
All right.
All right.
Mr. Chair.
Thank you, Mr. Chairman. Senator Serval, I think I kind of missed where you were going. I thought you were saying if the local government contracted with Mason Industries to provide this service to people in Fairfax County, that you didn't want to allow arbitration between the Fairfax citizen and Mason Industries. It seems like you're focusing on, you want to look at Mason Industries and make sure we're not hiding bad things in arbitration.
Right.
So, Mr. Chairman, we heard the banks. So small banks that may have banking relationships with localities aren't big enough to do, many of the things many of the services they provide. So they contract out with other companies, credit cards, all types of services. If those companies that they use for something that has nothing to do with the banking relationship they're setting up with the locality uses arbitration, would they have to, you said you narrowed down the things they have to report. Would the small local bank have to report that to the city of Williamsburg that says, yes, I use this card company and they use arbitration for these small things, or is that beyond the scope of the questions you're asking them to provide to the locality?
If it is a subcontract or purchase order related to the performance of the covered contract with the participating locality, then it would be within the reporting requirement. And I would also just point out, I remember now the second thing I was going to say in response to Senator McPike, who also asked about whether companies might not bid, which I think also Mr. Nolan said, or somebody said, is that if nobody bids, I would think they would stop asking the question. Like the locality would take that condition out of their RFP, right? I mean, if they're not getting quality bids or they're not getting what they want, they just won't ask. So if it's that much of a problem and they're not happy with what they're getting, they just won't use the authority we've given them. But there's other occasions where they would need the authority. And so that's why it's local option. It doesn't mandate they do it on everything. It just mandates that they do it when they think it would be appropriate. And I would leave it up to our localities to decide if they want to do that. It's just authority for them. And I would note the bill is supported by the Fairfax County school system, which has a $30 billion budget now, I think. And they would like to at least have the authority to do this. I mean, their budget it's 20% of what we spend at the state level.
All right, any other questions?
Have a motion? Motion, Mr. Chairman? Move to report.
All right, there's a motion to report. Is there a second?
Second.
All right, we have a motion and a second. Any further discussion? All right,
Mr. Chairman?
let's vote. Yes.
Sorry. Yeah. On the motion, I still have issues which are different from last year's version in terms of the compliance and post. I mean, in the 6-month interval updates, I mean, one miss and, you're potentially terminating a contract, which is a fairly substantial issue. This is different from what went through this committee last year, and I do have concerns I just want to express to the patron for that entire section.
You could always strike that section out.
All right, we have a motion and a second. Any further discussion? All right, let's vote.
Senator Vogel, how do you vote?
Senator Vogel votes no.
Ayes 8, noes 7.
All right, ayes 8, no 7. So
Thanks for slipping me in.
certainly, Senator DeStaff and then Senator Eben. Let's take it be quick. Sure.
Mr. Chairman, members of the committee, I have Senate Bill 1222. And Mr. Chairman, what Senate Bill 1222 does, it's another step in getting jobs restarted in the USA and Virginia. It states that procurement of PPE shall be purchased, one, by a Virginia-based company or manufacturer that uses materials and products components made in Virginia or the United States. When PPE is available from such companies or manufacturers, from a U.S.-based manufacturer using materials or products components made in the U.S. if available. The President of the United States signed an executive order strengthening Buy America provisions, ensuring the future of America is made by Americans, for Americans, by American workers. And as an example of this, PPE is a very, very good example of what's happened. PPEs primarily, like these masks that we wear, are made up of 3 layers. The inner layer is the one, the middle layer is the one that goes through and really hits the ASTM standards. Well, in China, the masks we were buying, we found the ASTM standards they said they were meeting, they truly were not meeting those standards. So what this bill does, like other states have done, there's 31 states that are currently looking at this, 14 states that already provide preferential treatment for things of this nature. What this bill does is it says if it's available in Virginia, if it's available in the United States and it's a reasonable cost, then we want to make sure that our PPE is purchased or made of those products. We've had problems with Chinese drywall in the past, Chinese tablecloths, Chinese steel, and more recently, the PPE we've been purchasing from China. So what this bill does is rectifies that, and under the new executive order that the President has put out, it ensures that when the federal government spends taxpayer dollars, again, this is what he had put out, they're spent by American-made goods, by American workers, with American-made components and parts. The executive order from the President fulfills the President's promise to make Buy American real, close loopholes, and allow companies to offshore production to bring those jobs back in the United States. I'm happy to answer any questions as well as go through the 31 states that have the Buy American efforts and the 14 that have Buy American laws with preferential treatment for things in those states, by those states, and I believe we'll have a couple of speakers as well, Mr. Chairman.
We have speakers.
Russ Rogers, or excuse me, Brett Bassey, please go
Brett
ahead.
Bassey.
Yes, Mr. Chairman. Thank you for the opportunity to address the committee. I think the senator has outlined this perfectly. We've gone through a pandemic. We've had a strategic shortage of PPE, primarily because the supply chain of both the materials and the manufactured products were primarily abroad. This issue has come through the Manufacturing Development Commission with Senator McPike is the new vice chair. So it was reviewed there. We're appreciative of Senator DeSteff bringing this bill forward. And this bill does not provide a mandate or a preference. What this bill does, it does require the procurement from a Virginia source if available. And if it's not available, if it's a foreign source, it must at least go through the American testing. That is really critical. As the senator pointed out, Virginia procurement, we know, is not validating all of those products for their same efficacy as US FDA regulated products. So we're asking for a fair and level playing field, and the lowest price technically acceptable on procurement, it just isn't cutting it. So this is why the bill has been introduced. We have two very important speakers. Russ Rogers is the CEO of BRS, and it is one of our most successful testing companies that also manufactures face masks. And we also have Bob Morris, who is the director of the Virginia Hand Sanitizer Consortium, which makes a large number of companies that have gone together to try to manufacture hand sanitizer during this period. And he has some important points, Mr. Chairman, and I'll stop mine at that. And we just ask for your support.
We have the next speaker now. Mr. Rogers, is that what it is?
Yes, Mr. Chair.
Good afternoon, and thank you for the opportunity to speak today. I'd start by saying that this is both about safety and jobs. As said, my name's Russ Rogers. I'm the Chief Executive Officer of Blackbriar Regulatory Services, and we strongly support this bill. We're a Virginia manufacturer of competitively priced 3-layer disposable face masks that, unlike many of the cheap overseas supplied masks, meet all ASTM and medical requirements up to FDA level 3. That means our masks have been independently tested for filtration efficacy and biocompatibility. We've already created over 75 jobs and manufacture millions of masks right here in Richmond each week. We can put a mask on customer shelves immediately. We even have our own trucking service, so there's no waiting for masks to come from 12,000 miles away that you don't know what you're going to get when they arrive. It's important to note that sadly, there are recent examples of state agencies foregoing our bid proposals in order to continue habit-based buying and actually paying more for inferior quality imported masks. We were then actually called upon to urgently fill a gap when those import shipments get held up in customs. There are even more examples at the other end of the spectrum of what appears to be anti-competitive dumping. It's important to support this bill as long as it prioritizes products that are actually made here in Virginia like
Just
we do.
1 minute left.
So not just repackaging, relabeling, and distributing, but actually product made here in Virginia. We need your support to keep our work going here in the Commonwealth. And thank you for considering our perspective today.
All right. The other speaker that was identified.
Doris Kraus-Mays, please go ahead. Please unmute yourself.
Yes, Mr. Chairman and members of the committee. My name is Doris Kraus-Mays, president of the Virginia AFL-CIO, and we stand in support of the bill. We need to make sure that if we have an opportunity, we need to have workers in Virginia with the jobs, and definitely, if not here in Virginia, it needs to say made in the USA. Thank you.
Thank you. All right. Those in opposition, who's first?
If so, please raise your hand.
Anybody speaking in opposition? Right. All right. Is there any discussion from the committee? All right. Does anyone want to make a motion?
Second.
All right. We got a motion and a second to report the bill. We'll vote on the board now.
Senator Vogel, how do you vote?
Stewart votes aye.
Senator Vogel votes aye.
Stewart?
13, noes 2.
Aye 13, no 2. The bill's reported.
Mr. Chairman, members of the committee, thank you so very much.
Does this bill need to go to finance? All right. Could we get another, just get a motion to report and refer to finance?
That was
All
the
right.
motion, I heard it.
All right, yeah. Your hearing's good, so, okay, let's vote on the board again here. We have a motion and a second? Second. Okay.
How do you vote?
Senator Vogel votes aye.
Ayes 13, noes 2.
Ayes 13, noes 2. All right, that passes and go to Senate Finance. Next up is Senator Evans, so, and then you'll be after that.
I'll be try and be brief. This is Senate Bill 1215 about unlawful eviction. And what an unlawful eviction is an eviction that is not authorized by the courts. And I should say first, there's a line amendment which would, I think council has it. It strikes after C on line 24. It strikes the remainder of line 24 through days on line 25 and instead inserts the initial hearing on the tenant's position shall be held within 5 calendar days from the date of filing of the petition. I would move the adoption of the line amendment.
All right, we adopt, all right, a motion to adopt the line amendment. There's a second. Anybody want to discuss? All in favor say aye. Aye. All opposed, no. The amendment's adopted.
Okay, so unlawful eviction includes unlawful removal or exclusion of a tenant from their property, deliberate reduction or freeze in essential services like utilities, or actions taken to make the property unsafe for habitation, like removing an exterior door during the winter. The bill increases a penalty, or I should say imposes a penalty, for unlawful eviction from actual damages plus reasonable attorney's fees to $5,000 or 4 months' rent, whichever is greater. The line amendment additionally makes it clear that judges would hear the cases of unlawful eviction within 5 days of filing by the tenant. Currently, there's no timeline, and you could imagine that if you're removed from your dwelling or locked out of your dwelling, that it would be important to hear the case in a timely way, particularly when you're without a place to live. So a July 2020 survey by the National Housing Law Project of legal aid attorneys nationwide found that 93% of surveyed attorneys were aware of illegal evictions in the region, and 53% had seen a tenant locked out of their rental property. And we know that evictions often force children to change schools, leading to long-term instability. Families may lose some or all of their possessions. Job loss, mental illness, lifelong poverty can occur as a result. The increased penalties will discourage bad actors from attempting to evict families outside of the legal process determined by the General Assembly. Currently, we know 33 states at least have significantly stronger damages than Virginia for unlawful eviction. And I have an unlikely cast of supporters from the Virginia Poverty Law Center and the NAACP, to the Apartment and Office Building Association, Virginia Apartment Management Association, and Virginia Realtors. And I can give you examples of people having windows removed in the winter, of people having power turned off, told that power couldn't be put in their name, and so forth. There's numerous examples from Danville and Charlottesville to Richmond and Fredericksburg. But that's the bill. It's simply a safeguard to prevent landlords from taking the law into their own hands and trying to evict people outside of the court system.
All right, any questions of the patron? All right, people are speaking in favor.
Consumer Litigation Associates. Please go ahead.
Thank you. This is Leonard Bennett. I'm also a member of the National Consumer Law Center Board of Directors, former Consumer Lawyer of the Year, and we won the Pro Bono Award of the State Bar in 2019. My first background was with the landlord-tenant work, and there are very few causes that at this stage in general need as much help as the rights of tenants. It is incredibly difficult, and I'm fortunate now that this George Mason grad could make a living, but the challenge is always finding lawyers that will do this. The best case scenario for a lawyer that's going to represent a tenant is to get some of your time back. It's not a profit center, and that's okay. A lot of lawyers want to do this stuff, but the more that's done to empower helping all of us, because every one of us, I'm sure, has at some point been in that boat, has been a tenant and the like. And I think this bill, as well as another that's coming up before this committee, are to be commended. And I'm appreciative as a Virginian, and certainly I think this would be a great improvement if you will enact it.
All right, thank you. Who else is speaking in favor?
Brian Gordon.
Brian Gordon.
Thank you, Mr. Chairman. Brian Gordon on behalf of the Apartment and Office Building Association and the Virginia Apartment and Management Association. As Senator Eben referenced, we are in support of the bill. We believe he has done a fantastic job of narrowly crafting this to where it will never impact our members who are responsible housing providers, and rather it will really just target and weed out, hopefully, the bad actors in the industry.
Thank you. Anybody else?
Yes, Mr. Chair. Christy Mara, and if you'd like to speak in support of the bill, please raise your hand.
Christy Mara.
Thank you, Mr. Chairman. Christy Mara with the Virginia Poverty Law Center, and we strongly support this legislation and thank Senator Eben for bringing the legislation. I'd actually just like to second the comments of Mr. Gordon in that this is, exactly as Mr. Gordon said, narrowly tailored to target those landlords who are acting outside the law to put tenants out of court out of their home without taking them to court and giving them an opportunity to put on their defense. And this really is designed to be a deterrent to landlords. The goal of this legislation is to finally find something that will stop these unlawful evictions, which quite frankly, have been going on since I started practicing as a legal aid attorney in the early 90s. And so I ask that you all support this legislation. Thank you.
All right, thank you. Anybody else?
Yes, Mr. Chair. Aaron Barton.
Barton.
Hi, Mr. Chair. Can you hear me?
Yes.
Excellent. I'll keep my comments short. I know there's a lot of people to speak. I echo the comments before. We thank Senator Eben for bringing this bill, and the realtors support it.
Thank you.
Kenneth Gilliam, please go ahead.
Good morning. Well, good evening now, Mr. Chair, members of the committee. My name is Kenneth Gilliam. I serve as a policy director for New Virginia Majority, and we strongly support this bill.
Thank you.
Ms. Hatcher.
Thank you, Chairperson, members of the committee. My name is Jace Hatcher. I'm the Economic Justice Program Manager at the Virginia Interfaith Center for Public Policy. We represent tens of thousands of people of faith and goodwill across the Commonwealth who believe that housing is a human right. And we also want to align our comments and our support with the speakers who have spoken previously and hope that you'll support this bill as well.
Thank you.
And our final speaker in support is Randy Grumbine, excuse me.
Thank you, Mr. Chairman. Randy Grumbine, representing the Virginia Manufactured and Modular Housing Association. We are in support of this bill and thank Senator Evan for carrying it.
Okay, thank you. Is that it? Okay.
If you'd like to speak in opposition to the bill, please raise your hand. I see no hands, Mr. Chair.
All right. We have a motion and a second to report the bill. Does this bill need to go to finance? Okay, it does not. All right. If there's no further discussion, let's vote on the board.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
All right.
Ayes 13, noes 0, 2 abstentions.
All right, thank you. Senator Peterson.
Thank you. This is Senate Bill 1198. And for those of you with a little bit of institutional memory, it should bring back a little bit of memories. It deals with license plate readers. Let me take my mask off so y'all can hear me. Senate Bill 1198 brings back a subject that we had legislation on back in 2014, 2015, and was back in the headlines last summer when the Virginia Supreme Court ruled finally on the Virginia Government Data Collection Act and said that the license plate reader data could be held effectively indefinitely by state agencies, which was a disappointment to the advocates who felt like the current statute already prevented that from happening. The way license plate readers work is essentially they vacuum up data. They are typically used by law enforcement, but also can be used by other government agencies, and will seek out and download information from license plates. And then they hold that information to see who's in a particular location, whether it's on a public highway, whether it's in a private parking lot, and stores that information and basically represents a database of all of our daily actions. And a lot of folks that are civil libertarians have an issue with that, have an issue with the license plate readers being able to go in and say, take an accounting on who's at a particular rally, who's at a particular shopping center, who's out on the road at a particular time. So the bottom line is this is a reprise of legislation I brought in 2015, which passed this body unanimously. It passed the House unanimously. The governor sought to amend it because they didn't like the 7-day rule, which said that basically the data has to be purged after 7 days. And then we rejected that amendment, and then the governor vetoed the bill. That's where the bill was. I didn't bring it back after that because basically this matter was in litigation for the next several years. The litigation has now been decided, so I brought the bill back. There is a substitute which I'll ask to be promulgated.
Mr. Chair, it is line amendments, and they should now show up on LIS.
Okay.
Oh, line amendments. I thought it was a substitute.
All right, so we have line amendments. Anyone want to make a motion to adopt those? Yeah. I'm sorry, I didn't hear that. I apologize. Okay, we have a motion to adopt the line amendments. All in favor say aye. Aye. All opposed, no. All right, the line amendments are adopted. Can you summarize the line amendments?
Yeah, the line amendments had to do with suggestions that have to do with a program from DMV about collecting data, and I'm going to let them explain it. And then I also believe some of the line amendments may originate with ACLU and have to do with some of the intricacies of the Supreme Court's opinion. I'm going to let, hopefully Claire's in the waiting room so she can speak to that. But
okay.
That's where it comes from.
All right. Are there any further questions of the patron? All right. Who do you have to speak?
I believe Claire is in the room. Claire, please unmute yourself.
Good afternoon, Mr. Chairman and members of the committee. Thank you for giving me a couple of minutes to talk about something that we've been working on for a long time. We worked closely with the senator back in 2015, thought we had a really reasonable compromise where there's absolutely no limitation on the ability of police to collect this data when they know that they're involved in a criminal investigation, and to keep it for as long as they need to in order to bring the investigation to an end. But what we're trying to do is prohibit people from collecting the data just because and just in case. At the time we were doing this litigation, the state police had 8 million records, including a record of every person who had gone across a bridge for the first Obama inaugural and showed up at a Sarah Palin rally in Prince William. And Prince William County at the time had LPRs on 995 that took a picture of every car that went by, and they kept it, indefinitely for at least 2 years. So the idea here is to protect people who are going about their business every day, for whom there is absolutely no suspicion that they are guilty of anything, and say that police cannot use this kind of surveillance technology unless they have a good reason to do so, and it's related to investigating a criminal activity. The amendment that was offered, one of the line amendments that was offered that deals with the definition of systems, is meant to address some confusion that was created by the Supreme Court's decision about what constitutes a database. And we don't want to be in a position where individual agencies can divide up their data and then say they don't have a system because it's not got an overlying access database portal that puts it all together in one inquiry. So the language is meant to make clear that if you are putting information together even after the fact, that you've got a system, and it's a database and a system, and you're keeping people's private information there. It's covered by the Government Data Dissemination Government Data Collection and Dissemination Practices Act. We think it's extraordinarily good that the General Assembly many years ago recognized that privacy in this new technologically advanced world was increasingly going to be an issue of concern for Virginians. There are some great whereas clauses at the beginning of this legislation that tell why you all balanced things the way that you did. And we think that the senator's proposal, again, restores the right balance, which is if you are an innocent person going to church or the doctor or to a shopping center or to a political rally, and your license plate picture is taken for no reason at all, that the government can only keep it for 7 days unless they have, it's part of a criminal investigation, and then they can keep it indefinitely until the criminal investigation is over. Very balanced, very straightforward. And, if you really think about what's really going on out there, we now have, most people don't know, there's a law enforcement information exchange database created by NCIS after 9/11 that marries data from every jurisdiction in the Commonwealth and across borders into DC and Maryland. And this is having this kind of data, collected in those kinds of systems and then preserved forever. It's the metadata that tells people a lot about your life. And when people look at this collected data, they know more about what you do and where you go than you can probably remember. So we strongly support this legislation. We urge you to pass it as you did in 2015. And let's move forward to protect Virginians' privacy in a reasonable way.
Is there anyone else to speak in favor?
Chair. Mark Siegel. And if you'd like to speak in support, please raise your hand.
Yes, I'm Mark Siegel. Can you hear me?
Yes.
Oh, yes.
Yes, thank you very much. So I represent the Hanover Sheriff's Office and Sheriff David R. Hines. And so I've been doing this for 38 years. In my experience, we, meaning the two departments where I've spent my time, we have never gone back and sifted through data unless we were looking for a specific license plate. We do not keep data. No one keeps data. We only keep what is equivalent to a picture. We have to go to a separate DMV database. And let me inject here that the last speaker just said that there was cross data sharing through NCIS. That is not. Those are police reports. It has nothing to do with that data heavy and data rich bank that we're talking about here. So what you're saying is that it's essentially okay for 7 days for us to keep the data, but we can't keep it beyond that. So when we talk about notorious crimes involving terrorism, murders that occur in neighborhoods, and now people are getting smart and they're leaving their telephones behind. so that we can't track what they did when we have a specific suspect. We would never be able to go back and query data. So if we had an act of terrorism in Northern Virginia, which is where the Pentagon is, where they've had it before, we would not be able to go back. So if someone were casing the Pentagon and otherwise, we could not go back and simply query a system that held nothing but license plate numbers and zero personal information. I repeat, we have to go to other databases, and you have to be law enforcement sensitive, if I could say that correctly, in order to query DMV. The other thing is, in the decision of just 3 months ago of our state Supreme Court, they agreed with that. So if this is no different than if I, as an individual, or I, as a police officer, took a picture or made a video on the corner of traffic at 9th and Broad in downtown Richmond, that I would have to delete that after 7 days. Because that is all we're doing. That is the passive system. The active system of LPRs is when officers are riding around and they have it, and they're hooked to the state police. And this is simplifying it, just to tell them if they pass a stolen vehicle, or if there's a wanted person for terrorism or something else like that, or an Amber Alert. But they have to use other information to verify that. They cannot stop a person based on that. If you have any other questions about this, I'll be glad to answer them. Again, I represent the Hanover County Sheriff's Department, and thank you very much.
Thank you. One more speaker in opposition. Huh? Okay, he was not in support, so. There's one more in support. Who's that?
I believe it's Claudia Arco.
I think they're in opposition. Yeah. All right. Claudia Arco.
So, Mr. Chairman, we are in opposition. I'm Claudia Arco with Fairfax County. So do you want me to speak now, or do you want me to wait a minute?
Yes, go ahead and speak. I'm not sure we have any other speakers in support.
Okay. Thank you, Mr. Chairman. So I'm Claudia Arco with Fairfax County. I think I also have Captain Pedri from the Fairfax County Police Department if you all have questions about how we use the license plate readers. Really, the county's position is that a reasonable retention period is something that the county is comfortable with. We feel that 7 days is too short a time period for some of the reasons that were mentioned by the previous speaker, and Captain Pedri could speak to that as well. I think also the county does have concerns about trying to treat license plate information as personal information for a variety of reasons. Also, I would just mention Senator Peterson talked a little bit about the court case and having been completed. My understanding is that court case, while there was a ruling from the Supreme Court, the litigation is in a little bit of a holding pattern because the plaintiff filed a motion asking the Supreme Court to reconsider its ruling, and the Supreme Court has not acted on that motion. So I'm not sure it's completely finalized. And so I just wanted to make the committee aware of that. And so I think hopefully Captain Pedri is on there. And so if anybody would like to hear about how the county uses the license plate information, I'm sure he'd be happy to share some information. Thank you, Mr. Chairman.
All right.
Mr. Chairman?
Yes.
Can I ask what time frame they'd be comfortable with?
So, Mr. Chairman, I think we haven't really settled on a particular time period. I think there has been a discussion of 60 days, 90 days, 120 days. I think there has been some discussion in the law enforcement community, and so maybe Captain Pedri could speak to that. I think we just feel like 7 days is very, very short, and so it doesn't give a lot of time for real investigative utility, if you will.
Mr. Chairman, if I could ask a follow-on to that question.
Yes.
How long do you keep the data now?
Well, I think right now we're under an injunction because of the court case, so I don't think we're using that information at the moment.
Mr. Chairman, if I could clarify, before the court injunction, how long did you keep it?
I hesitate to ask this question, to answer this question, because I think there were different periods of time where information was being retained for different periods of time. I think many years ago, it was potentially for a year, but I think the retention periods got shorter over time. So, I think a year was about the longest we had ever retained the information.
Mr. Chairman.
Mr. Chairman.
Senator Mason.
Thank you, Mr. Chairman. We've wrestled with the time limit on this thing for a number of years, but I'd like to ask the lady who was just testifying, deeming it personal information jumped out at me as well, and she said that she had some thoughts on the concerns about deeming it personal information. Could she elaborate on that for us?
Sure. Sure. So, one of the concerns that's been raised to us from our law enforcement officers is that making it personal information could have impacts on other areas of the law. So, security cameras, police in-car video, body-worn cameras, all of which capture license plate information when they're recording. And so, if the license plate information itself becomes personal information, it could be captured in other ways, and so that could have maybe an unintended consequence.
Mr. Chairman?
Thank you.
Yes, Senator Boysko.
Thank you, Mr. Chairman. A question for Claudia. Could you explain to us what the county uses that data for now, or besides what you just talked about a second ago? Just trying to understand exactly.
Sure. So if Captain Pedri is on the phone, I would prefer that he talk a little bit more about the actual law enforcement uses of some of this data. I think he is on the line, so I don't know if he needs to be brought into the room, Ashley, if that's possible.
What was the name?
Pedri, P-A-G-E-R-I-E. Maybe if he raises his hand, you can see it. There, Rex Pedri, yep. I think he probably needs to unmute.
All right, am I on?
Yes.
Yes.
All right, do you need my video on, or is it, here, I'll start it.
We can hear you, whatever. So
Okay, sir, I'm happy to answer any questions. I've been the LPR coordinator for Fairfax County for many years. I've been involved in it since 2001. And I'm certainly very active in the Harrison Neal lawsuit that went on for 6 years. And to confirm that, we are still under an injunction. It has not been lifted, and our retention period is 0 at this point, which has adversely affected our investigations, especially with missing persons and suicidal subjects. It's really hurt us and hurt the citizens and victims in Fairfax County, having that injunction in place. Because with missing persons, I'll tell you, we have about 1,500 missing persons a year in Fairfax County. That could include abductions and silver alerts and so forth. That's our go-to. I worked in our special victims division, and child exploitation and child abuse was under my umbrella. And LPR was one of our go-to tools that would give us a starting point to go back in time, essentially using that passive data to establish where a missing person had been, or a suicidal subject to go and save their lives. This injunction has drastically impacted our investigations. And I can touch base on the longer term retention, why it's important to keep that. The previous talker from the Sheriff's Department touched on the terrorist acts and things like that. And I'll give you the incident we just had on the 6th with the Capitol building. LPR data can be used before and after to see who was involved in that. Many cases, people will go and scout out a location if they're going to do a school shooting or a terrorist act or something like that. LPR data, it could be used to as a tool, investigative tool, to narrow their scope and give investigators the right direction where to go. I did want to touch a little bit on what Mr. Peterson said. Like I said, the injunction's still in place, so we're still under that restriction. But I wanted to clarify some misconceptions with the LPR database. Like the sheriff said, it's merely just like taking a picture with your smartphone and storing in your photo album. The only difference is it takes that letter number combination and it runs it against a list that's has a list of that same number letter combination that is on the hot list provided by the state police. Now that would alert us to, missing person, abduction, stolen vehicle, someone who's wanted for rape. The list goes on and on. This is a tool that helps us take very bad people off the street. To restrict that data retention to 7 days is unrealistic. Some of these cases are very complex. We had a murder investigation a year later through LPR data. We were able to get a vehicle of interest. That was the banker who was a world banker who was murdered in his home. There's cases from around the country where passive data has been used to solve crime. I mean, the list goes on. And if I just touch base on making this personal information, to reiterate, think about any device that captures a picture of a license plate. That becomes personal information, which would fall under the Data Collection Dissemination Practices Act. Now, if that were the case, all body camera, all in-car video, the cameras that are outside the courthouses, the cameras that are outside of schools, any public building would be affected by that. So we would not be able to store that. So if there was a person who would go into a courthouse and say do a shooting, how would police officers go back and look at that data to find out who was there, why they were there? Maybe they were there 2 weeks earlier to scout out their actions and get their plan of attack into place. That's why it's important to keep that data for longer periods of time. Now, I would like to see 180 days. I think that's realistic. 90 days, I think, is a compromise. I can tell you, being in the major crime section, investigations are methodical. They take time. There's a lot of restrictions in place for law enforcement these days as far as the hurdles we have to jump through to get from point A to point B to solve a crime. And frankly, staffing is an issue across the Commonwealth. Here in Fairfax County, we have a staffing issue with our major crime section. We should be double the size we are. They're overworked. Their caseload is beyond capacity. And to get to a case where you have a 7-day time limit, it puts us in a race for time. And it's just not there for us. It's not a realistic date to set. I think 90 days is a compromise. Like I said, 180 days is doable. We have very long-term investigations, and I'll give you one more example. We had 2 young men or boys, basically 14-year-old boys, murdered in Fairfax County by MS-13. Their bodies were buried in Holmes Run Park. We didn't find out about those death locations until months later. Maybe even one of them might have been a year later. LPR can be used to go back in time and create leads for us to find a suspect. Now, this misconception that we're tracking people and there's personal information in our database is completely false. It is a picture of a letter number combination and a GPS location. It gives you no nexus to any database, DMV, NCIC. There's no link whatsoever. Like I said, it's just like taking a picture and putting it in your photo album on your smartphone.
All right.
That's
Thank you very much. Senator Boysko, does that answer your question?
Apparently the filibuster's still
Appreciate
alive
it.
in the Senate.
Yeah.
Mr. Chair.
Yes, Senator Peterson.
I want to answer a couple of those points because, in the time that gentleman was speaking, I had the chance to actually read the bill about 6 times. And almost every single situation he was talking about is already an exception to this bill. It's already an exception. If there's a pending investigation, if there's a missing persons report, that's already exempted. Also, if you notice, the agency's under an injunction right now because there's no statutory authority for using these license plate readers. So actually, this would actually give a framework to use the license plate readers. The injunction would be moot as soon as this bill hits the governor's desk and is signed. I mean, we could put an emergency clause on it and the injunction goes away. So that objection misses the whole point. I'm trying to set up a framework. In terms of the 180 days, I mean, that's not a compromise to me. Again, that's a database that the police have of your movements for 180 days, and I don't think that's what this is about.
Mr. Chairman. Mr. Chairman, and just a question for the patron. Senator, I was just curious, we're talking a lot about limiting the data collection on law enforcement. Does it also include practices that extend to, for instance, tax administration? I understand that these license plate readers are also used to identify vehicles that aren't on the tax rolls, and the 7-day limit would be pretty prohibitive, I think, in order to make that identification and follow up. So I was wondering if the bill also covers other agencies beyond law enforcement.
Sure. Yes, I can answer that. Here's the bottom line. These license plate readers are also looked to identify vehicles that have not paid personal property tax, okay? But the bottom line is they'll get the hit on that right away. If they go through a neighborhood and they scan the license plate, they'll know right away if a license plate represents a vehicle that has not paid personal property tax. So I don't have any problem with using license plate readers. Again, this is a framework to use them. What I have a problem with is storing the data indefinitely. Now, 7 days, ironically, was the compromise we reached in 2015. There's nothing magic about it. If you said 15 days, I'm not going to scream. I think 6 months is a little bit extreme. 90? All right, well, that's a little bit much, and I think Claire's probably having a heart attack right now. But the bottom line is you can't hold it indefinitely. There has to be some type of cap on use.
Mr. Chairman.
Senator Reed.
I might have missed it, but question for the patron, with your legal hat on.
Yes, sir.
Trying to understand, body cameras are an active investigation when they're on. They're constantly on. I'm talking to somebody that I pulled over or whatever. I understand that part. Right. How are these cameras on these cars, explain the difference between the legal part of that.
Okay, a body camera is a camera you turn on because you're walking into a situation where you're going to be confronting a suspect or a witness, or you need to record the conversation. So that is, by definition, not of unknown relevance. It's of relevance to that situation. This is a passive collection of data where a police vehicle may be driving through a Fair Oaks Mall parking lot, or it might be scanning a church parking lot, or it may just be scanning cars coming down 95 and just accumulating the data, storing the data. Claire made the reference to a camera on 95 catching cars going north to the inauguration or to a political rally, just scanning the data, capturing the data, and holding the data. And again, it's this whole idea that we're under a microscope and there's this record of our movements for months. That is what is disturbing.
Mr. Chairman, follow-up question. Jeb, I've been former law enforcement. I understand how long some of these cases is, and Jeremy and I were talking as well. With the technology gains that we've made, we're going to know if a vehicle's stolen pretty doggone quick if one of those readers pick it up, or if it's a child that's been abducted and the technology is there now that surpasses this. Where are you comfortable? The officer, the detective said 90 days in Fairfax County, which is one of our largest counties, municipalities that does police work. I would think Virginia Beach would be the same. Is there a number in your head that would make everybody kind of comfortable where we can move forward?
I think my colleague, the police representative, the police chief, was clever that he set the boundary out as what you called the compromise pretty far out there. Like I said, I remember at the time I brought this bill, it was 72 hours. Right. And we compromised to 7 days. If you get me to 30 days, whatever, I'll take it. And I just want to set up a framework.
How would you feel about 45 days, Mr. Chairman? That's not like quite 90. It's kind of cut in half. 90.
I like 30 better.
Mr. Chairman, I would make the motion 30 days if the patron is amenable to that, so we can throw our law enforcement a little bit bone and they have to work a little harder.
We have a motion and a second to change 7 to 30. Any discussion on that? Yes.
Yeah, I would only add, I mean, we all have just about cell phones. These are connecting to towers as we move around. I like the bill. I think it's a good thing. I think 30 days is probably makes sense, but our data is being tracked with these, and I don't know how long that's around, but it's even more accurate than these license plate readers. So, but I would go with 30 days.
All right.
Mr. Chair?
Yes.
Thank you. I would also, put my comments along with Senator Bell's. Satellites can pin down and see you sitting in your living room anywhere you are. I mean, we are already being watched. There are already people who are able to monitor us. I don't want us to have a false sense of security. I think we all just need to acknowledge that in the information age, smart cities and other technology is here now. And, I think it's something that we all have to reckon with. I like the concept of this bill, but I'm still a little bit uncomfortable with it after hearing from the police. So just wanted to say that, but I appreciate the effort.
If there's no further discussion, the motion is to 30 days. All in favor say aye. Aye. All opposed, no. All right, that amendment passes, so we now have 7 is 30 now. So.
All right, I'll make one closing comment
Sure.
to Senator Boysko. And because of the Fourth and Fifth Amendment, there are restrictions on law enforcement that private companies don't have. So this is all within that context.
Right, right.
I'd like to move to report the bill as amended.
All right, we have a motion.
Does
this one need to go to finance? All right, so we have a motion and a second to report the bill as amended.
And Mr. Chairman, just one quick thing. I appreciate the patron carrying this bill. He knows as soon as that court case came out, he was the first person I called. I said, Chap, you putting in a bill? And he said yes. So it saved me a bill slot. So thank you.
All right, with that, we will now vote on the board.
Senator Vogel, how do you vote?
Senator Vogel votes no.
Senator Reeves, how does Senator Stewart vote? Ayes 9, noes 3, 3 abstentions.
All right. Certainly. All right. Next up, we have Senator Suderline, Senator Morrison, and then Senator Chase, who's on the. Are you going to move there next week? No. Well, I don't plan to, put it that way.
Just emailed me and said they're working on some amendments.
Okay.
I wanted to know if we could get letters over
Okay, I'll work with you on, we sort of may have a meeting at the desk or something if need be, so.
I don't know if that's going to resolve all the issues, but.
All right, Senator Suderline, you're up next.
Thank you very much, Mr. Chairman. Bill I bring before the committee today is Senate Bill 1131. What it seeks to do is right the current imbalance regarding emergency orders. Most states have legislative involvement in emergency orders. It prevents the executive from having unlimited, unchecked emergency orders beyond an actual emergency. The whole idea of an emergency power is to be used when something is truly emergent, not because a situation is not good and needs handling, but because it truly is emergent, in the same reason why we all understand the difference between going to the emergency room and needing to go see a doctor. There's lots of things that we need to go see a doctor on, but we don't need to necessarily go to the emergency room. There are some things the governor certainly needs to be able to do. Every governor should be able to do that. What this bill would do is provide the governor the ability to issue emergency executive orders that would last for 45 days. And then if the General Assembly has the opportunity to vote in the affirmative to continue that, and if we do not, the governor can't reissue the same order. This is something that is very common in other states. The Roanoke Times wrote an interesting editorial about it, where they talked about my approach and at the time some other legislators' approaches, and they compared to which state each of us was like. But the bottom line was that this approach of having a legislative check on emergency powers is common throughout the country in states with very different philosophies on government. And I think it's important that we bring that balance here in the Commonwealth. Currently, a governor can issue an emergency order, and it goes until June 30th of the next year. And that's not an emergency. That might be something that we really need to address, but that's not what an emergency power is supposed to be. So I hope it will be the pleasure of the committee to act favorably on Senate Bill 1131.
All right, are there any questions of the patron? there anyone to speak on this measure?
At this time, I'd like to remind people in the queue to speak that we are presently asking you to raise your hand only if you'd like to speak in support of the bill.
Vic Nichols, please go ahead.
3 minutes for each side.
Vic Nichols. Stephen Rossi. Stephen Rossi.
Stephen Rossi.
Mr. Chairman, can y'all hear me?
Yes, yes.
Okay, I'm still getting used to this stuff. Mr. Chairman, members of the committee, my name is Steve Rossi. I represent the Family Foundation of Virginia, and we support the bill for the reasons the senator stated. Particularly like his analogy to the going to an emergency room or not needing to go to an emergency room. We think that's a perfect analogy. Hope the committee will look kindly upon the bill. Thank you.
All right, thank you. Anyone else?
Vic Nichols, could you please unmute yourself?
Thank you. The founding fathers created America so that we would not have one person ruling over us. We have checks and balances for a reason, and that's what we need. The other issue is the concern of what they call an emergency. The emergency was more so of where all the deaths are, which is the over 70 age range of 73.5% of deaths in there. And those are mostly people in the LTCFs and nursing homes and the like, which the state is supposed to be overseeing. That is where the emergency really is. We need to make sure that facts prevail. Thank you.
Thank you. Is there anyone else to speak in favor? All right. Is there anyone to speak in opposition?
If so, please raise your hand. Curtis Brown, could you please unmute yourself?
Curtis Brown.
There he is.
Curtis Brown.
Sorry, good evening. My name is Curtis Brown, State Coordinator of Emergency Management, the Virginia Department of Emergency Management. Speaking on behalf of the administration, strongly opposing this bill as it will limit our ability to implement and take life safety measures for disaster. Our disaster recommendations are guided through our Commonwealth of Virginia Emergency Operation Plan that governs our response to pandemics, hurricanes, floods, and terrorist attacks and civil unrest. The limitations put upon the ability to declare a disaster by this bill would also endanger the Commonwealth to have to spend millions of extra dollars because we would not be able to get reimbursed through the federal government through the disaster declaration program. So there is a fiscal impact to this bill as well. That concludes my comments. Thank you.
All right. Is there anyone else in opposition? All right. Just so everybody is aware, I've talked with both Senator Suderline and Senator Newman, who had a similar bill here, and said that I thought that this was probably not the time in which to do this during the middle of the state of emergency, but that once we get past the state of emergency, we'll set up a subcommittee to be able to wrestle with this issue and come up with some recommendations and to work with the administration on that. So,
Mr. Chairman, in light of that, I move we politely pass the bill by indefinitely.
All right, we have a polite passing by indefinitely motion, and along with a second. Any further discussion? All right, all in favor? Let's vote on the board.
Senator Vogel, how do you vote?
Senator Vogel votes no.
Ayes 8, noes 7.
Ayes 8, noes 7. All right. I'll be in touch, so. Hopefully around June 30th, so. All right, Senator Marsden, and then we'll have Senator Chase after that. Senator Marsden.
Thank you, Mr. Chairman. We have Senate Bill 1392, the Data Privacy Bill, which, Mr. Chairman, it is time that we find a meaningful way of protecting the citizens of the Commonwealth of Virginia's data. This is a big effort. We've put in weeks and weeks of work, had Zoom calls with dozens of stakeholders in this process. We've entertained all kinds of amendments and changes to the bill to satisfy the needs of numerous industries. And Virginia's in a unique position, Mr. Chairman, to be a leader on this issue because a huge amount of the data on the internet flows through the Commonwealth. Privacy is not a new issue, and this bill incorporates feedback from many stakeholders here in Virginia. It also builds on years of work by jurisdictions like Washington State. Overall, this is a consumer protection bill that is focused on giving consumers control over their data. Currently, under Virginia law, consumers do not have the right to control their personal data, and this bill would provide for that. The enforcement of this effort, Mr. Chairman, is the Attorney General. He is best positioned to provide consistent enforcement. Attorneys General are traditionally where consumer protection enforcement is housed, and in every state that has passed consumer protection legislation, the Attorney General is the enforcement mechanism. The bill is carefully tailored to balance consumer protection needs and compliance requirements for small businesses. If a business is not controlling or processing a large amount of consumer data, then they will not be subject to this legislation, as is consistent with California, who has the first bill out on this topic, but it has a number of issues that we hope to solve here. There's a delayed enactment on this bill until January 1 of 2023. And I would tell you at this time, Mr. Chairman, that the administration, and we're not doing it today, but either on the floor or in the process of this bill going back and forth from the House, they want to keep a stakeholder group going to continue to work on some of the minor details that may come up. And I think that's a good thing because we do have time. The bill does not become effective until January 1, 2023, so we've got time to deal with these issues. This bill contains all the key elements to protect consumers and is cleaner, simpler, and easier to understand than what was passed in California. This is important for Virginia consumers and businesses. So what does the bill do? The bill sets a baseline to give consumers control over their personal data, provide companies clear expectations, and leverage best practices without creating excessive or unreasonable compliance burdens. The bill would explicitly provide consumers of the Commonwealth with the following rights: the right to access their data, the right to correction of that data, the right to deletion of that data, and the right to opt out of collection and sale of personal data. It also delineates the responsibilities of the controllers, who are the people who own the data, and the processors, who are the ones who distribute the data or use it on behalf of the controllers. But it clearly puts that out, what their obligations are. Provisions in the bill are consistent with best practices and/or requirements in place in other states to make compliance more efficient. And Mr. Chairman, on the phone, on the screen, for any truly technical questions that may be beyond my scope of knowledge, we have Stacy Gray, who works for Future Privacy Forums. And this is a group that's funded by people like the Robert Wood Johnson Foundation, some corporate funding, but they're there to be the experts, not to advocate for anybody's position or any industry or whatever. They're just the data privacy experts, and Stacy Gray would be my phone a friend on the screen there for anybody who has some technical questions. And Mr. Chairman, with that is the outline of the bill.
Mr. Chairman.
Right, Senator Donovan.
Is there an amendment or a substitute, perhaps?
Excuse me, this is a substitute. Yes, we would need to adopt.
All right.
Chairman, I'm giving a substitute on LIS now.
So we have the substitute on LIS.
I believe so. DLS told me last night that they were putting it on there.
Okay. All right.
Mr. Chairman, it should show up on LIS on the bill history page.
All right. All right. There's a motion and a second to adopt the substitute. All in favor say aye.
Aye.
All opposed, no. The substitute is now before us, so.
Thank you, Mr. Chairman. And take any questions?
All right, any questions?
Mr. Chairman.
Senator Ruff.
To take care of the concerns that the electric co-ops had?
Senator Ruff, we are still working with them on that. We have a plan as this bill goes back and forth to solve those problems, but we do have, I believe, agreement with the co-ops that the plans that we have in place as this bill moves through the process will solve their problems. Yes, we've worked very closely with them. Believe it or not, in Northern Virginia, I have Novec, which is a co-op, and pay close attention to what their needs are. So I think we're on a good path with regards to solving the issues that they have.
All right, any other questions? Is there anyone?
Mr. Chairman,
Yes.
I've got a couple questions,
Yes,
and
Senator Mason.
maybe for the patron or the lady on the screen. I don't know which one. Trying to match up my lines. Lines 120 to 122 on the substitute. Process data of 100,000 consumers or control or process personal data of at least 25,000. Deriving over 50% of the gross revenue. Do we know how many companies we're talking about? And
Senator Mason, I do not know that number. Perhaps someone who is on the call here could provide an estimate of that number. I don't think it's anything you could ever get exactly.
Sure.
But we may have an approximate idea.
Mr. Chairman, maybe a better question was, did we just pick these round numbers, or were these targeted numbers that we knew there was a strata or a level? Or
Senator Mason, this bill has worked its way through the state of California, and they have a product that has some issues. The state of Washington is the one that we have sort of based this on, and they did not have quite the issues, although they couldn't get it through last year. They're attempting it through this year, and I think these numbers are just generally agreed upon numbers that people can remember, that seem fair. And that the people in the data privacy business understand or deal with some breakpoints between smaller and larger businesses.
Yes, sir. Mr. Chairman, just one or two more.
Yes, Senator Mason.
I'm trying to find it. I think it is line 184 on the substitute. It speaks to obtain a copy of your personal data and make sure it's portable, allowing the consumer to transit the data to another controller without hindrance. How does that work? Does that mean you contact a company that has your data and they transport it for you, or I don't understand that.
I could make an assumption here, Senator Mason, but if I could call on Stacey Gray from the Future Privacy Forum to perhaps answer that question. Stacey, are you there?
Yes, she is. Ms. Gray.
Sure thing. Thanks, Senator Marsden. I can try to answer that question. It would not require the company itself to port the data, but would require them to provide it in an accessible and portable way. And that would basically prevent companies from sending you 100 pages of a PDF document that isn't machine readable, for example, right? So it kind of gets to some of the data portability aims of the bill without directly requiring porting.
Okay, and one more, Mr. Chairman.
Yes.
On lines 229, it speaks to not processing data in violation of state and federal law, unlawful discrimination, we shall not. I mean, it speaks to all these things that you can't do that sound like they're against the law today. Are they targeting practices in the industry, or why do we spell out those things that would, I hope we're not doing any of those today.
Ms. Gray, could you answer the question?
I'm sorry, did you say 229?
Yes,
I'm not
ma'am,
sure I'm seeing.
in the substitute, number 4.
Number 4, sorry about that. So in section 4 there, I would say there are two things, and I'm not sure which one you're asking about. So one is that controllers can't use personal data to violate existing anti-discrimination laws. That's a common thing in privacy laws, to just tie those provisions to existing federal and state anti-discrimination laws. And the second portion of it has to do with loyalty programs, discounts, and premium features. So that refers to discriminating against consumers for exercising their rights under this bill.
Got it.
Does that make sense?
Yes, ma'am. And I was asking about the first. Thank you, Mr. Chairman.
All right. Any other questions of the patron? All right. Are there people to speak on this? Let's do 3 minutes on either side. 3 minutes on each side.
Mark Dix, you're our first speaker, but if you have, if you'd like to speak in support, please raise your hand.
I'm opposed.
Ryan Harkins, please go ahead. Please unmute yourself.
And I'm sorry, Mr. Chair, did you call Ryan Harkins?
Yes.
My apologies. Mr. Chairman, my name is Ryan Harkins, and members of the committee, I am a Senior Director of Public Policy for Microsoft, and I'd like to thank you for the opportunity to testify today. We support SB 1392. We think it is a thoughtful approach to modernize United States privacy law, something which has become a very urgent need. We at Microsoft have been calling for comprehensive privacy laws in the United States since 2005. And the reason is that we think having strong, robust, comprehensive privacy laws is essential to earn the public's trust in technology, something which we have lost a bit of late. And therefore, we support the bill. We think it would provide consumers with a robust set of rights to protect their data. We think it would impose affirmative obligations on companies appropriately to be responsible stewards of the data that they process, and it would provide protections for civil rights, something which we also think is important. Finally, we also think that the bill would be good for business for a number of reasons. First, it would help to earn back the public's trust in technology, at least on issues relating to data privacy. It would allow companies to continue to innovate responsibly, and it would provide clear and consistent rules that are consistent with laws that are being adopted across borders, therefore making it easier for companies to comply with data privacy laws. So we thank you for your leadership in considering the bill, and we support it.
All right, thank you.
Please go ahead. Bill Way.
Thank you, Chairman Baker and members of the committee. I'm Bill Way, Associate General Counsel for Privacy at Amazon. I appreciate the opportunity to speak to you in support of Senate Bill 1392. We believe this bill will enable consumers to enjoy the benefits of technology while feeling confident that their personal data is being handled responsibly and transparently. At Amazon, earning our customers' trust is fundamental, and we know we must get privacy right in order to meet our customers' high expectations. We support legislation that requires transparency about data practices, prohibits the sale of personal data without consent, and ensures that consumers have the right to request access to and deletion of their personal information. Senate Bill 1392 achieves these goals. It secures privacy protections for Virginia consumers while providing certainty to the business community in how to build effective data protection programs. This bill would establish Virginia as a leader on consumer privacy. As the home of our growing headquarters, we're excited to see the Commonwealth advance legislative proposals like these. I want to thank Senator Marsden for his leadership on this important issue. Thank you for your time.
All right. Good. If there's anyone else to speak in favor, just come on and identify yourself and indicate your position on the bill.
Matt Brunning, please go ahead.
Mr. Chairman, members of the committee, Matt Bruning with the Virginia Bankers Association. For the reasons explained before, we do strongly support the bill and encourage you to pass it.
Thank you.
Maureen Mahoney.
Mr. Chair, members of the committee, thank you
Yes.
for the opportunity to speak today. My name is Maureen Mahoney. I'm a policy analyst at Consumer Reports. We haven't taken a position on the bill, but we very much appreciate that you're considering it because it would give Virginia consumers important new privacy rights, the right to access, delete, and stop the sale of their information, broadly similar to the California Consumer Privacy Act. These protections are long overdue. We do think the bill should be adjusted to make it more workable for consumers, such as adding a provision that would allow consumers to opt out with a single step, given the difficulty that consumers have had opting out in California. We also recommend removing the right to cure provision in enforcement, which inappropriately ties law enforcement's hands. We recommend considering these amendments as the bill moves forward. Thank you for the opportunity.
Thank you for your testimony. Anyone in opposition?
Yes, Mr. Chair. We have Mark Dix, and just a reminder, if you'd like to speak against the bill, please raise your hand.
Good evening, Mr. Chairman, members of the committee. Mark Dix on behalf of the Virginia Trial Lawyers Association, and we oppose the bill. We understand and appreciate the intent behind the bill. It's a noble purpose. Data breaches, the unauthorized use or sale of consumer data is a growing problem. And we also appreciate all of the hard work that went into this. This is a good start, but this is not the right approach. This bill provides no cause of action whatsoever to the consumer. It also provides no remedy whatsoever to the consumer whose data has been violated. This bill is going to hurt Virginians. It's going to close the courthouse doors to the consumers. The one person the bill is designed to protect is the one person that has no cause of action and has no damages. Relying upon the Attorney General is not enough. What happens when an administration changes? What if we get an Attorney General for whom this is not an important issue? Private, and even if that Attorney General does enforce, again, no damages to the consumer. Private attorneys are more than able to prosecute these claims and advocate for consumers. Again, we appreciate the intent behind this bill, but this bill insulates big technology. That's all it does. And that's why you're hearing big technology in support of it. So we hope the committee will reject the bill. Thank you.
All right.
And finally, we have Consumer Litigation Associates.
Hi, this is Leonard Bennett. I'm with CLA, but I'm on the board of the National Consumer Law Center, was with the National Association of Consumer Advocates and Advisory Council for VPLC. First of all, Senator Marston and the other proponents should be commended for taking this on. I would suggest, though, that there has been despite all the voices, there were zero consumer voices now. We weren't involved. None of the organizations were involved. This bill is a model of the Washington Privacy Act, which was rejected last year. It's advocated by the industry. It is not a consumer bill, and it is not adopted either there and hopefully here. It also does not solve the biggest problem, which is how do you cause consumers to know of these rights? There's no educational component. There's 5,400 some data brokers, Senator Mason, plus lead generators. The primary proponents, the bankers and the Google and Amazon are largely uncovered by this. And that's okay, because while imperfect, it still would be a good bill. The AG, I believe, will speak at finance, where the fiscal impact is $330,000 minimum, and indicate, I believe, that this is an unworkable scheme, suggesting that the AG would be responsible for all of this, for investigating 5,400 plus data brokers and the like, is untenable. And on the other hand, you don't need to suggest that this should be a feeding frenzy for personal injury lawyers. And no disrespect, I'm on the Williamsburg Society VTLA, and myself, I'm a plaintiff's lawyer. But you could model the Virginia Value Act, which was enacted last year. And the Virginia Value Act says a consumer makes a complaint, takes it to the AG. The AG, I believe, I don't want to speak for them, but I have reason to believe they would confirm that this model is already in place and they could do it. And then the AG would then say it's founded or unfounded. And only then, if it's founded and the AG cannot prosecute it, would the consumer be able to take their action and go to court? That would solve a lot of the problems. It would make it viable, enforceable. It wouldn't offend the proponents you heard to speak today, who are largely unregulated, because this primarily targets those that make a living selling data. And it would accomplish what Senator Marston and Delegate Hayes so much have fought for. And while you may or may not make that amendment today, we certainly think that you should make that amendment. Make that amendment either in finance on the floor, but this bill as it is right now is an industry bill, frankly, designed to suck the momentum out of alternatives in various states around the country where consumers have been pushing these types of bills. This is the industry alternative.
We're a little over time on this.
Senator Barker, I appreciate it. I don't have any more to say. Thank you for all your hard work. I know everybody's had a long day.
Yeah. All right. Thank you. Nobody else? All right. Senator Marsden, you want to sum up?
Thank you so much. We reached out to everybody, and I do not believe the Virginia Trial Lawyers Association got involved in the process with us. They came in late with just a very pleasant phone call to me that they were trying to get to yes and on the bill. And clearly they're not there. In the state of Washington, the private right of action is what killed the bill. That would kill all the support that we have gotten from industries all over the Commonwealth, from consumer groups that have indicated some support for this direction. In terms of the Attorney General's costs, there's a fund that's established here, and any fines and what have you that are collected will be able to pay for these kinds of efforts. Now, there may need to be some money up front, but hopefully it could be a self-sustaining effort. But we have got to get moving. And the beauty here, Mr. Chairman, is that this doesn't take effect until 2023. The administration is going to work with us to keep a group going to deal with some of the problems that perhaps some of the folks who are not in favor of the bill will have a chance to work in more detail on it. It's the best of all worlds. We don't have any financial concerns right now because of the 2023 start date for the bill. We have got to start protecting our people's data. It's time, and Virginia is the place to do it. 70% of the internet comes through Virginia. We're not Wisconsin. They're responsible for cheese. We're responsible for the internet. Let's get it right.
Mr. Chairman.
Yes.
Senator Mason. Mr. Chairman and Senator Marsden, if we move this along to finance, I think what Mr. Bennett just mentioned at the end sounds like an interesting thought process, because we are addressing Senator McClellan's bill. We're working out some things now, but she's emphasized that the Attorney General investigates this, and there would have to be a founded complaint, as he mentioned, before you'd ever move to a private right of action. So you mentioned the private right of action killed it in Washington. Well, so I'll just ask you, if we move this to finance, to pursue maybe the thought process that the Attorney General investigates, and if it is founded, then you maybe move towards, and if not, there's no need for it. So I just ask you to consider that along the way. That seemed like an interesting hybrid to me.
That methodology I'm not familiar with. Perhaps Ms. Gray, very quickly, could you address that, whether that has been a successful strategy?
It's a great question, and I think it's an example of the kind of interesting compromise that people are starting to talk about, in not just yes private right or no private right. It's a hard question because in the privacy context, that really doesn't exist in any law yet. In the EU, of course, you see similar mechanisms where data protection authorities are required to respond to complaints, and that's been very successful in a number of instances. In the US, most of the provisions of the California law are enforced by the Attorney General in California, and the current Washington bill, at least in the Senate side, is enforceable by the AG. So, hard question. I know it's more common in other non-privacy laws.
All right. Any other questions? All right. Is there a motion on the bill?
Move to report and refer.
All right. Report and refer to finance. Is there a second?
Second.
All right. Any further discussion? All right. Let's vote on the board.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
Ayes 13, no 0, 1 abstention.
All right. Thank you. All right, next up we have Senator Chase, and I think you have 3 bills, Senator Chase, to present to the committee.
Thank you, Mr. Chairman. Can you hear me okay?
Yes.
Okay, very good. Mr. Chairman, Senate Bill 1449 is a COVID-related bill regarding to immunizations and as it pertains to prohibiting or requiring any type of employment discrimination would be prohibited. Mr. Chairman, there's a lot of concern right now among constituents in my district that as a source of employment, they would be required or forced to receive a vaccination, and not getting that vaccination would result in either termination of employment or failing to get a job. This bill is in anticipation of any future requirements that would come up in the next year or so relating to the immunizations. I believe it's a personal choice for people to get the immunization or not. People have different opinions on it, and I respect people's ability to make that choice for themselves. I've always said, I've always been a proponent of personal responsibility, educating oneself and making those decisions according to a person's specific medical conditions or needs or their unique situation. So we should educate, not mandate. It should never be a class 1 misdemeanor, et cetera, for not following a government's mandate. Mr. Chairman, specifically, this bill prohibits discrimination based on a person's vaccination status with respect to any COVID-19 vaccine, specifically in numerous employment contexts. It is self-evident that there is nothing more personal than the human body of an individual, whether for oneself or a parent or on behalf of a child. The individual's unalienable rights, certainly and without equivocation, encompass the right to choose what is done to the body. Mandating a substance be injected into is a fundamentally a violation of those rights. And that's Christine Smith with the Future of Freedom Foundation. I would also say there was a quote: compulsory vaccinations are an assault on an individual's unalienable rights of life, liberty, and the pursuit of happiness as enshrined in the Declaration of Independence. And again, Christine Smith of the Future of Freedom Foundation. That said, Mr. Chairman, I'm also concerned about some of the side effects. Do we want to risk compelling someone to take the vaccine to protect their career and support their family and risk the chance of suffering such side effects? What are the risks of the Pfizer COVID-19 vaccination? Side effects that have been reported with the Pfizer vaccine have included injection site pain, tiredness, headache, muscle pain, chills, joint pain, fever, injection site swelling, nausea, swollen lymph nodes. There is a chance that the Pfizer vaccine could cause a severe allergic reaction, which we have actually seen. A severe allergic reaction would usually occur within a few minutes to an hour after getting a dose of the vaccine. For this reason, the vaccination provider may ask you to stay at the place where you receive your vaccine for monitoring after vaccination. Some of the severe allergic reactions can include difficulty breathing, swelling of the face and throat, a fast heartbeat, a bad rash all over your body, many other symptoms that are listed here, Mr. Chairman. And with that, I know I have a number of speakers who wanted to speak in favor of this bill.
All right, are there any questions?
Yes, Mr. Chairman.
Yes, Senator Eben.
So I just would like to clarify with the patron. I understand her philosophy of personal choice of what people do with their bodies, but when it starts to impact other people, I'm wondering if with healthcare workers or deputy sheriffs, does this mean a hospital would not be able to see that its employees are vaccinated and not spreading the virus to patients, or similarly in jails where people are confined?
So thank you for the question. And I would say to that, I think it's a matter of educating the individual and allowing them together with their employer to make that choice. But I don't think that it should be a mandatory that someone could not work. There, we have to take into account religious exemptions or exemptions where there are people who have legit medical reasons where they cannot get the vaccine. And we've seen multiple allergic reactions. We haven't even seen the extent to all of the allergic reaction. As you know, Virginia is number 50 in rolling out the vaccine. So we don't even know all of the reactions at this point. And so I think that this bill is one that gives that decision to the employee to make with together with their employer to come up with that decision, but it should not be mandated by a government official or agency or state.
All right, are there other questions?
Mr. Chairman.
Yes, Senator Ruff.
Senator Chase, I understand what you're trying to accomplish, and I appreciate that, but I do have a concern that we are telling a business that they cannot operate their business as they would like to do. Does that give you any heartburn?
Well, I believe that businesses should be able to make that decision for themselves. And there is actually another bill that limits this to government agencies, to your point. And I believe there are two drafts of this bill. One is 1449, and I believe the next one addresses your good question there. And that will be addressed in 1450, which is the next bill I'll be presenting.
Actually, Senator Chase, on that point, as I read 1449, it starts out dealing with policy of state agencies and other things in terms of state government. But there are other provisions that are in here, and actually on lines 820 through 822, it says, this shall prohibit a hospital, nursing home, or certified nursing facility from requiring any employee of the hospital, et cetera, to receive any immunization against COVID-19. So this bill at least is dealing with both public and private businesses, and basically saying that even in situations where you have medical facilities that are dealing with people who are there because they have COVID-19, that they cannot make that requirement.
I appreciate the comments, Mr. Chairman, and on that, just keep in mind that the reason this bill was introduced is a number of concerned constituents came to me who are in the industry, and just some of them have expressed to me that maybe we could create some type of medical exemption. If a person has an allergic reaction to the vaccine, we would hate for them to lose their main source of income because they were not able to get an immunization. I mean, currently they're not immunized, they're wearing the mask. So potentially, they wear the mask as it is now. And if they're unable to get the vaccination, they could still at least have the ability to work and provide for their family.
All right, are there other questions of the patron?
Mr. Chairman.
Yes, Senator Donovan.
Just to comment, working in a hospital, we know that the hospitals are working to get everybody vaccinated because everybody does have the right to decline. It's in the Patient's Bill of Rights. It's number 4 in the Patient Bill of Rights that you can decline. I think it's very different to talk about the state forcing people to get vaccines than it is to get involved in private sector contracts where an employer might say, we need to have you immunized unless you have a medical exemption, which everybody would have. So I am concerned about the business components that Senator Ruff pointed out, and I am not able to support this bill, whereas I have supported the bills that prohibited the government from mandating it.
All right, are there any other questions for the patron? All right, let's do 3 minutes for each side on this bill. Start out with those who are in support of the bill.
I'd like to remind those in the queue presently to please raise your hand at this time only if you wish to speak for the bill. If you wish to speak against the bill, please put your hand down.
Robert Melvin.
We're speaking against the bill.
David Rosnick, please go ahead.
Sorry, can you hear me?
Yes, proceed.
Okay, sorry about that. I'm Dr. David Rasnick, PhD with degrees in chemistry and biology. I have 20 years experience in the pharmaceutical biotech industry. The so-called COVID vaccines are not actually vaccines. They are untested gene therapy drugs that insert viral genetic material into human cells. By calling them vaccines, the FDA is allowing the widespread administration of these experimental gene therapy drugs. This is very risky business, especially since the CDC and the manufacturers have acknowledged that the COVID vaccines do not produce immunity to the COVID virus. 2, they do not protect a person from COVID symptoms. And 3, they do not protect a person from transmitting COVID. A decade of scientific literature on experimental gene therapies makes it clear that the so-called COVID vaccines are likely to be extremely dangerous to humans if administered on a massive scale.
All right, we're down to about 2 minutes.
Too many people have already been killed and injured within hours to weeks after being injected. These gene therapy drugs under the guise of vaccines are likely to kill and injure millions of Americans, if not tens of millions. It is irrational, abhorrent, unethical to inject an adult or a child with these experimental concoctions that have no demonstrated benefit or even purpose. For the sake of your children and loved ones, I plead with you to prohibit forced or mandated vaccinations. I also plead with you to prohibit coercing, penalizing, and punishing anyone who refuses these gene therapy vaccines. Finally, these pseudo vaccines are setting a precedent for people to accept genetic altering drugs. The result will be GMO people. I support the bills.
Thank you.
Joe Ordia,
We're down to 1 minute.
please unmute yourself. Please unmute yourself. You're still muted.
Yes. Good evening, Mr. Chairman, members of the committee. Can you hear me all right?
Yes.
Great. My name is Joe Ordia. I'm speaking on behalf of Virginia Freedom Keepers and also just as a concerned father and husband. And I'm going to be talking tonight about religious liberty because this issue of discriminating in the workplace against an individual based on their religious beliefs or their vaccination preference, I see that the issues are very, very much linked. There are many people in the medical freedom community that view any type of a vaccination mandate as a direct assault against the health of their children. And we're talking about hundreds of thousands of people here that believe that their safety and the safety of their children may be threatened by policies like this that allow employers to discriminate against people based on that vaccination preference. Now, I know that here in Virginia, we have a long, proud history of respecting our citizens' religious liberty, especially as it pertains to what type of medical treatment to accept. Some people do not believe in blood transfusions. Some people do not believe in organ transplants. And if we were to discriminate or to restrict access to employment of those citizens based on those strong moral and religious beliefs, then I think we're doing a disservice to the citizens of the Commonwealth.
All right.
And so let us show the people and the nation that freedom is still alive here in Virginia. Thank you.
All right. We'll now hear from those who are opposed to the bill. 3 minutes for that side now.
Robert Melvin, you'll be our first speaker, but just a reminder, if you'd like to speak against the bill, please raise your hand.
Okay. Mr. Chairman, members of the committee, Robert Melvin with the Virginia Restaurant, Lodging, and Travel Association. We have some serious reservations with this bill as it's currently drafted and the way that it interjects into the employer-employee relationship, especially with how devastated the restaurant community has been. It's important for us to be able to go and ensure that our restaurant employees are able to get vaccinated, and that's going to be a critical part of the recovery. I'd also like to point out that there are already important exemptions that are in place for individuals with disabilities or sincerely held religious beliefs. So I think that that's kind of misleading to use that as a guise for pushing this measure. And I would urge you to vote against it. Thank you.
Thank you. Next. there anyone else in opposition? All right. Yes? No, we do not. Okay, no, not. Okay. All right. All right. We have a motion to pass by indefinitely. Senator Chase, do you want to make any closing comments?
I just think this is a critical personal freedom bill that allows people who are unable to get vaccinated. It should be a personal choice to not be penalized in the employment sector. And I think it's important that we respect people's individual liberties and not force them to put foreign entities in their body without their permission and to make it subject to employment. I think is a violation of everything we stand for as Americans, personal choice, personal freedom. Thank you. Thank you, Mr. Chair.
All right. With that, we have a motion to pass the bill by indefinitely with a second. If there's no further discussion, we'll vote now.
Senator Vogel, how do you vote?
Senator Vogel votes no.
Ayes 11, noes 1, 1 abstention.
All right. Thank you. All right. Next bill, Senator Chase.
Thank you, Mr. Chairman. This is Senate Bill 1450. This bill is almost identical to the bill that you just sought, so I will literally simply just say that it once again prohibits discrimination in employment based on a person's vaccination status with respect to COVID. I need to look through the language of the bill. If you want to go ahead and go to my speakers who are speaking in favor of this bill, it'll give me an opportunity to finish my statements.
Yeah. Are there differences, Senator Chase, are there differences between the 1449 and 1450 as to what entities and what employment is affected?
The intention of the bills, which is what I'm trying to find out right now, one had to do with government entities, and the other one would address the one that I'm doing now is supposed to specifically relate to government entities, and that's what I'm checking right now. And that would be the main difference.
All right. Are there questions of the patron?
Mr. Chairman, can council look at it and tell us?
Yes, Ashley, can you explain differences between 1449 and 1450?
Mr. Chairman, I believe Senate Bill 1450 does go through the different titles that deal with discrimination on the basis of pretty much anything and adds the vaccination status with respect to any COVID-19 vaccine. But there is no further language like there was in 1449 that deals with, for instance, the hospitals not being able to require their employees and things of that nature.
Thank you, Mr. Chairman.
All right.
Otherwise, they're pretty similar.
Pretty similar there. All right. Let's go to the speakers then. We'll do 3 minutes for each side. So we'll start out with those in favor of the bill.
If you would like to speak in support of the bill, please raise your hand. Jody Piles, you'll be our first speaker.
All right. We have 3 minutes for all the speakers in favor of the bill. So.
Yes, my name is Jody Piles, and I'm a business owner and a pastor in Radford, Virginia. I support both the previous bill and this one. I personally feel that as a business owner, acquiring and maintaining employment should be based on a person's education and their abilities, and not on the possibility of becoming sick or getting some virus that has a 0.04% in the state of Virginia fatality rate. There's plenty of other things I can add here, but to be short and give others a time to speak, I'll just say, basically, I think this violates a person's civil rights in a major way. Thank you.
All right.
Dr. Patricia Powers, please go ahead.
Thank you, Mr. Chairman. I am in favor of this bill. This bill allows religious exemptions to be officially written into this legislation. allowing employers to mandate participation in the COVID injection program does violate the legal protections already in place to protect our freedom of religion. There are some reasons why people would object on a religious basis for vaccines, and one of them is just the opportunity to rely on faith or prayer to promote one's health. There are also some objections to the cell lines derived from aborted fetal parts or cancer cell lines that are used in production and manufacture of these vaccines or testing of these vaccines. There are many unknowns about these COVID injections, and they are experimental genetic products. We don't have long-term safety data, and to mandate employment for these kinds of products, I agree, does violate one's civil rights. Thank you.
And finally, we have Vic Nichols.
All right, we have a little over 1 minute to go.
Thank you. I have had a reaction to a vaccine. I should not be at the point of losing my job or my life to a requirement like this. If my body, my choice works for abortion, every last one of you owes me an explanation of why I should take a chance of death or lose a lifetime of productive work here and be stuck on the dole because y'all would not see fit to make exemptions for a number of us. I asked a ton of questions. The medical end of COVID, the BDH could not justify, couldn't back up anything, and then finally refused to talk to me because they couldn't produce medical information compared to what I had showing that this was not what it was. I would like to have my life. Thank you.
Thank you. 15 seconds, anyone else?
Yes, Mr. Chair, we have two. Eric Hedberg.
Good evening. Eric Hedberg, self-employed boat carpenter. This is a matter of conscience and self-determination. A determination is made whether a person receives treatment of any sort. And if that determination is made without and not by that individual, that's a trespass. It should not be allowed in any way, shape, or form. We thoroughly and unequivocally support this bill and Amanda Chase and her efforts.
All right.
Amen.
Thank you for your testimony. All right, now, any individuals to speak in opposition?
If so, please raise your hand. Robert Melvin, would you like to speak against the bill?
Yes. Mr. Chairman, members of the committee, Robert Melvin with the Virginia Restaurant Lodging and Travel Association. I would just, I guess, like to point to the previous comments I made and you know, say that we're opposed to this measure just as much as that previous one. So please oppose it and thank you very much for your time.
All right. Anyone else? All right. Are there other questions or comments from the committee?
Mr. Chairman?
Yes, Senator Evan.
You know, I think that we already have our religious protections, and there is no mandate for vaccines in Virginia as it stands, but I'm going to make a motion to PBI this bill.
All right, there's a motion and a second. I will point out that this bill deals with public entities at the state level, but among those who would be covered under this would be the authority that operates MCV hospitals and would basically prevent them from being able to have vaccination as a condition of employment for the state hospitals. So we have a motion and a second to pass by indefinitely. If there's no further discussion, we will vote on the bill at this time.
Senator Vogel, how do you vote?
Senator Vogel votes no.
Wait, she's here. Hold on. Are you a yea or nay? This is the PBI.
Ayes 10, noes 4.
All right, ayes 10, noes 4. That bill is passed by indefinitely. And then you have one more, I think, Senator Chase.
Thank you, Mr. Chairman. Senate Bill 1451, once again, is a COVID vaccine related bill expressing, once again, just you can hear from a number of constituents and those across Virginia who this is very strongly personal to them and their employment. This bill basically is ensuring that we have options for those who cannot receive a vaccine or choose not to receive a vaccination, that they would not be denied access to state or local public properties by persons who choose not to receive the COVID vaccination. Mr. Chairman, this bill gives equal access to state and local public property by persons who choose not to receive the COVID vaccinations, prohibits state agencies and localities from denying the use of certain public facilities to any person based on such person's vaccination status with respect to any specific COVID vaccine. We want to make sure that individuals who choose not to get the vaccine are not denied government services. Not everyone can and should get the vaccine and should not be denied services for refusing to get the vaccine, especially for essential government services, and to ensure that those who need the services the most are able to get those and not denied. Mr. Chairman, I'd like to give the rest of my time to those who have so kindly joined in the queue today. If I could give some of my time to them, to some of the constituents across Virginia who have heartfelt reasons why they support this bill.
Mr. Chairman, Senator Reeves.
All right, Senator Reeves.
Question for the patron of the bill.
Certainly.
Senator Chase, have there been instances already in the Commonwealth of Virginia that would warrant carrying this bill that the government has denied people the access to those properties because they have not received a COVID vaccination?
Senator Reeves, as we've talked about on the floor of the Senate, we're number 50th in the state of receiving those vaccinations. There's still a very small percentage of the majority of Virginians who have had access and been able to get the vaccine. What this bill does it actually follows the pattern that we've seen with the mask. And many folks who, are mandated that they wear the mask and are denied services. And yes, even in state facilities. So I would assume, based on that precedence with the mask, that there would be people, or could potentially be people, who are denied access to state and local public property based on their refusal to get the vaccine. I'm simply following a precedent that's already been set here in Virginia regarding masks, and see the vaccine as following suit.
With all due respect, Senator Chase, do you have filed complaints from people or patrons or constituents that have been denied access to public government real property, is what the bill says, based on their non-vaccination status?
So I will defer to some of those who are desiring to speak in favor of this bill.
All right. Are there any other questions? All right, let's go to the public testimony. Do 3 minutes for each side again.
Dr. Patricia Powers, and again, if you'd like to speak in support of the bill, please raise your hand.
Thank you, Mr. Chairman. I support this bill. I am very much in favor of personal choice and not using immunization, vaccination, injection status to determine employment, to determine access to services, government property, public property. This is a matter of personal choice and enforcement of our personal freedoms. I am a pediatrician. I am a board certified pediatrician, pediatric endocrinologist, and small business owner. Thank you.
Thank you. Next.
Jody Piles, please go ahead.
Yes, once again, I'm Jody Piles, pastor. One of the hats that I wear is I serve warrants for the state of Virginia, and I can already see where people are limited access based on just the mask mandate. So I want to applaud Senator Chase for getting ahead of the ball and being able to stop this as a mandate prior to it affecting us. You know, it's one thing to stop us from going to private businesses or whatever if you choose not to go to those places because you are choosing not to get a vaccination. But this would limit me being able to walk into courthouses to obtain the papers that I serve, which is the way I make money. It would eliminate going into courthouses, DMVs, all those places that, you know, we have to go on a regular basis. So as a citizen of Virginia, I find it ludicrous to think that you would have to have a vaccine in order to do regular business in the state. And based on the way it's already progressing with the mask mandate, it seems that the vaccine could very well be a possibility in the future. Thank you.
Thank you. Joe Ordia, please go ahead.
Yes, good evening again, Mr. Chairman, members of the committee. Joe Ordia here for Virginia Freedom Keepers. And I'd just like to say that people that choose not to accept a vaccination based on their strong moral and religious convictions, these citizens still pay taxes. These citizens should not have their rights to access public parks, public schools, or any other taxpayer-funded government service restricted because of their observance of their strong religious convictions as it relates to what medical treatment they accept.
Really quick, I would like to say something. I graduated from Tucker High School. I went to VCU, and my mom encouraged me to get the Gardasil shot going into college because it was recommended. I was injured by that. I chose not to get the second round and the third round. I don't understand why you would be forcing parents when there hasn't even been enough time. Like, it should be our choice what we do.
A vote against this bill is a vote for medical tyranny. We are one more step closer to papers, please, going into the park or the school or the grocery store. We don't want to live in a society like that. And I thank Senator Chase for introducing this legislation. Thank you.
All right, the time is up on those supporting. Is there anyone in opposition to this proposal?
If so, please raise your hand. I see no hands, Mr. Chair.
All right, no hands raised. Is there? Okay, we have a motion to pass by indefinitely and a second. Is there any discussion?
Mr. Chairman?
Yes.
Speaking of the bill, Mr. Chairman, I understand the premise of what this bill says, and I've read the bill like 10 times already of what they're trying to say has happened, which out of the testimony I've heard not one person speak that they were denied government services or going into a building because they didn't have a vaccine. Mr. Chairman, I will be the first person to stand in this chamber and holler foul if the government starts denying people based on their immunization records for services, but there is no evidence of that happening, and I think this bill is a little bit before its time, and I would second the motion.
All right. Any further discussion? All right, we have a motion to pass by indefinitely. Vote on the board.
Senator Vogel, how do you vote?
Senator Vogel votes no.
Ayes 9, nays 5.
All right, ayes 9, nays 5. That bill is passed by indefinitely as well. All right, next up is Senator Lewis.
Good morning.
It's good you're not driving home to the Eastern Shore tonight, but
1389, Mr. Chairman. And there is a substitute.
all right. Your attention to Senate Bill 1389. I think that's what he said.
And there, as I said, Mr. Chairman, there is a substitute, which I think is probably up on the system now.
Mr. Chairman, I've posted the substitute, but I've gotten word from our ITD last that LIS may be down, but the members should be able to see the substitute on y'all's internal portal.
What's an internal portal here?
Mr. Chairman, I'm not sure what you all have access.
I'll turn my head, Mr. Chairman.
I have no idea what you're talking about. All right, Senator Lewis.
I'll give it a go, Mr. Chairman. Mr. Chairman, members of the committee, Senate Bill 1389 is
Did we adopt the substitute?
Oh, I'm sorry, no.
Yeah, all right, is there a motion to adopt the substitute?
Motion. So moved.
All right. We can't see it, but we'll adopt it anyway, so.
It's out there now.
All in favor of adopting the substitute, please say aye.
Aye.
All opposed, no. All right, moving along.
All right, Mr. Chairman, members of the committee, Senate Bill 1389 is an effort to put a period at the end of a evolving and increasing policy discussion, particularly in coastal Virginia and Hampton Roads, but actually all throughout the Commonwealth, where recurrent flooding is an issue, and that involves real estate disclosures. So I bring this bill on behalf of Virginia's realtors in an effort to be proactive and address, as I said, what has been an increasing conversation. I believe this panel has discussed similar measures over the last couple of years. And so, as I said, these folks have worked with interested parties, again, particularly in Hampton Roads and coastal Virginia, in order to come up with this. The substitute that's before you primarily addresses some concerns that were raised by the administration. This bill, the original bill, had a significant fiscal impact in it. We believe that the substitute removes any significant fiscal impact because it does not require the creation by DCR of a new website that would be populated by information already on VCR relative to flooded properties. So this bill, the substitute, does two things. It amends the buyer beware form that currently exists to direct potential home buyers as part of their due diligence to a flood risk information website at DCR, Department of Conservation and Recreation, so the buyer can determine the flood zone of the property that they're looking at. The amended buyer beware language will also direct potential buyers to a flood risk information form that will be on the DPOR site, Department of Professional Occupation, whatever. This form will use information from FEMA to explain the flood hazard areas and what flood insurance, what the terminology is and so forth to the potential buyers. And you can see language for the form is actually incorporated into the bill. And the second part of the bill creates a mandatory disclosure form from a seller to a buyer. And what this says is that if you have actual knowledge that the property is, by FEMA definition, a frequently, or actually the technical term is repetitive loss structure, then you would have to disclose that. FEMA defines that as a property that has had a $1,000 flood claim, two or more $1,000 flood claims within the last 10 years. And so that's a change. And again, this is an effort to answer some concerns, rising demands for more transparency in real estate transactions. As sea levels rise and we have increasing ferocity of storms and more water inundation, these things, and again, particularly in Hampton Roads, particularly in the district that I represent, are becoming more and more of a problem. So again, the realtors, in an effort to be proactive, have come up with this disclosure bill, which hopefully will keep future bills from being considered by you all in the next several years. So that is the bill, Mr. Chairman.
All right, and just for everybody's enjoyment, the LIS is back up and does have this substitute there. So you can read the 7 pages of the substitute if you want to. So.
Mr. Chairman, move to report.
Well, Mr. Chairman, can I ask a question real quick?
Yeah.
I beg your pardon. This is a good one, I think. So on line 152, it says, "What is a flood?" Question mark. A flood is a general and temporary. Have we ever seen a question mark in the code?
Well, no, that's the form.
That's the FAQ.
That's
okay, so we're writing the FAQs into the code.
Yeah.
I feel better already. Thank you, Mr. Chairman.
All right. Is there anyone to speak on this bill?
Thank you. Thank you.
If
Much
you'd like
appreciated. It's cocktail hour.
If you'd like to speak in support of the bill, please raise your hand. Our first speaker is Virginia Wasserberg.
All right.
Please unmute yourself.
Hello, my name is Virginia Wasserberg. I live in Virginia Beach, Virginia, and I participate in a local advocacy group called Stop the Flooding Now. And flood disclosure is something that we've been working on with the General Assembly for the past couple of years. I am a victim of flooding here in Virginia Beach. My house flooded in 2016. I no longer reside in that house, and it is important to myself and others with Stop the Flooding Now that we accomplish some level of flood disclosure in the Commonwealth of Virginia. And I just wanted to be here today and support Senator Lewis in this bill, because we really believe at Stop the Flooding Now that this bill is a very good bill. It's a very good step in the right direction of continuing Virginia being a buyer beware state, but also addressing the need of flood disclosure in Virginia. So I ask very respectfully that this committee supports the bill. Thank you, Mr. Chair.
All right. Is there anyone else to speak?
Yes, Mr. Chair, we have one. Aaron Barton.
Aaron Martin.
Thank you, Mr. Chair, and thank you to Senator Lewis for carrying this bill for us. My name is Erin Barton. I'm with the Virginia Realtors. We have worked extensively over the past many months on this bill, trying to strike a balance between our representation of buyers and sellers. We've had great communications with the administration. We think this bill is the answer we've all been looking for the past several sessions, and strongly support it and ask you to move it forward. Thank you.
All right. Is there anybody else to speak in favor? Is there anybody in opposition?
If you would like to speak against the bill, please raise your hand.
Mr. Chairman, I renew my motion to report the bill.
All right. Does this need to go to finance? Okay. So
And refer to finance. Yes, sir.
So, okay, we have a motion and a second to report and re-refer to finance. If there's no further discussion, we'll vote on the board.
Senator Vogel, how do you vote?
Senator Vogel votes aye. Sorry, was on mute.
Ayes 14, noes 0.
All right. Are there any other speakers out there? Any other presenters?
They are sleeping.
Yeah. Yeah.
See anyone, Mr. Chair, but I'll check.
Okay. The only. Yeah. All right. If there's no one else, then we will now go through the bills from members of the committee. Let's first deal with the there are four bills deal with gaming, charitable gaming and other related things. What I'd like to do is to take up have presentations on each of those four bills and then combine the questions for those, and then we'll vote on all four bills. So we'll start with 1127, which is Senator Reeves.
Mr. Chairman, is it okay to take it there since most of us are here? Or you want the dais?
They're going to go up here, yeah. All right. Need your exercise, so. Go ahead.
Thank you, Mr. Chairman. Everybody hear me okay? Mr. Chairman, for the committee is Senate Bill 1127. Each of the members have on their desk a little PowerPoint to which I put together. And let me just preface this with the original bill I had was to try to help charitable gaming, and I'm still trying to do that. But, Mr. Chairman, many of you know me. For the last 9 years I've served here, and I've always tried to do what I consider sometimes the hard right over easy wrong. And When I had the original bill, I was asked to carry the bill because there was our charitable gaming is really hurting right now with regard to bingo, and bingo is their major draw. As I started to look at some of the challenges with regard to what they were struggling with, I just happened, literally, Mr. Chairman, to go into a business within my own county to have dinner. Mr. Chairman, as you'll notice on the first page, I went into Hard Times Cafe and walked in and I thought I was in a casino. And if you'll look on page 3 of the handout that you all have, that's what I looked at. In that same facility, which was an open bar, basically, there were the other games that are games of skill that actually had tags on them. I didn't include those, but they were marked and signed. The ones that are overseen by ABC had all their required registration and everything else. However, none of these had any of that. I also came across a document that showed where these were flyers basically advertising the fact that if you're playing these games, there's no tax to you. And so, Mr. Chairman, you know, when we talk about charitable gaming, I'm going to tell you right now, Mr. Chairman, it's out of control. You know, the original purpose of our statute was to allow VFWs, fraternal order police, fraternals, to have some gaming on their premises for their members and their guests. 2 years ago, in this chamber, and I worked with several of you, we refused to allow charitable gaming in bars and restaurants. That was House Bill 2302. Well, charitable device companies apparently decided to do it anyway. Even though we said no, they're popping up in many bars as the example I have shown you. And there are more. There's hundreds more. They've systematically proliferated. As you saw, some are advertising, where you pay no tax, etc. The activity is currently not regulated. None of them. In all these locations, there's zero enforcement. Let me say that again. Zero enforcement on these games. And the way they're bypassing the system and taking advantage of it is they're creating these social quarters, which if you have ever frequented VFWs, American Legion halls, there's usually a cantina is what we call it at my American Legion post to the in the same building but in a separate room next to the big bingo hall, where veterans can go in and they'll have pool tables and some of these games and some other things. And so what we have here now is really commercial gaming. And so what I did, Mr. Chairman, was I tried to rein that in a little bit, you know, and there's just, I don't want to say it the wrong way, but I'm just going to say it like I see it happening. It's kind of sham or fiction that is for charity. And there's no guarantee that any of the money in the social quarters goes to charity. Why? Because there's zero enforcement. There's zero way we check it. Well, I'm going to tell you the market is currently grossing about $1 billion of untaxed, unregulated, and unenforced monies. $1 billion that this Commonwealth is not getting anything. So I have them in my district. Many of you have them in yours. If you're happy to want to know which ones are in your district, I'll be happy to tell you because I've done some homework, police work. But let me tell you what my bill does. It requires a universal permit that applies to all charitable gaming. The substitute, yes, sir. No exceptions. It brings everybody on one regulatory authority under VDAX, and we can have a discussion about VDAX if that's the proper entity that needs to oversee this. And I want to thank Mr. Menifee, who is in a very difficult position to try to help regulate these things, and he answered a lot of questions for me. The bill closes the, quote, social quarters loophole, so we're not going to see these things proliferated in bars and restaurants. It rolls back charitable gaming to some of the original folks that we allowed this for, federally recognized VFWs and fraternals, moose lodges, etc. But it does allow for first-time bingo halls to participate in electronic gaming due to declining bingo players, because that was their primary gripe, was that bingo was tapering off. We're in COVID, people can't get together, and they still needed that revenue. The bill requires gaming to be conducted only on their owned or leased property, not bars, restaurants, hotels, strip malls, etc. It doesn't hurt the small mom and pops, the 501c3s that are just trying to bring a little money for their organization, and not, I say again, and not those that are trying to become gaming houses or mini casinos. The bill also increases the amount of money that can be used for better enforcement. I've spoken to Senator Howe. In the bottom of the substitute, it talks about raising the percentage that goes back to VDAC. Right now, all those monies, those of you that are in Senate Finance will understand this, actually go to the general fund, and then those are reappropriated back to VDACs. But if we're going to require a universal permit, of which some of the entities won't pay a dime to get it, but it'll allow at least the oversight for us to be able to go in and audit when we have some of those situations happen where we're trying to find out what they're giving. And Mr. Chairman, that are the fundamental points to what the bill does, and I'd be happy to go through and pick it apart. I also have, hopefully, I think David May is online, who helped kind of draft the bill, and the thought process of what we were trying to do is to bring some oversight into an industry that is absolutely circumventing the process and the will of the General Assembly of what we were trying to do. I'm not happy that I'm doing this. The patron that asked me to carry the bill asked me to strike the bill, but I'm not going to do that because I'm trying to fix an industry. If we want to be able to help our charities, which I do, trust me, I just want to make sure we're doing it right, and that's the bill, Mr. Chairman. I would do that, Mr. Chairman, so moved. Mr. Chairman, there are some very substantial changes to the initial bill that was filed, and I've worked through what those try to do. I'll be happy to have David help me go through line by line on those. Is it possible to ask if David's on? Okay, that'd be great. Let's have her kind of walk through what's the difference.
Mr. Chairman, I'm sorry.
Oh, go ahead, Ashley. Pardon me.
I don't believe that David May is on. And I know he was very instrumental in drafting this bill.
Yeah, Mr. Chairman, I was going to say that the patron actually outlined the substitute fairly well in terms of the substantive changes within the code in his presentation.
Mr. Chairman, just to clarify, so does this mean that if I walk into a restaurant now, I will no longer see these games in restaurants? They'll just be in the fraternal organizations?
Mr. Chairman, Senator Evan, this is going to help clean those up because we don't know where they are.
But they won't be authorized or legal to be outside of
no,
this?
it's very defined. I think if you go down, and let me find a section of where they can have them and how they have them, it has tightened it up pretty good. So it's going to get rid of some of those. Yes, I think, Mr. Chairman, to answer Senator Evans.
I think maybe it's line 293 where it says only at locations at which the organization is authorized to conduct regular bingo games.
You're correct.
Okay, I thank you. And are there limits on the, Mr. Chairman, if I could follow up?
Certainly, Senator Evan.
Are there any limits on the hours, or are they any different than they are now?
Mr. Chairman, we did try to give a little bit back to the charities to allow them greater consideration to change some of those hours. I believe they were, if I remember right, because we've been through 3 generations of trying to go back and forth and get the players involved. It's 3 days. Let me go back through the bill and try to find it. The copy I have is not highlighted, so I need to go back and look at those changes. If council knows it before me, No organization may play instant bingo, network bingo, pull tabs, or seal cards on more than 3 days in any 7-day period. So that would be line 277 through 278.
I thank the gentleman.
All right, any other questions of the patron? All right, is there, we'll get to testimony later after we do all four.
Mr. Chairman.
So,
Mr.
yes.
Chairman. So, line 252 in the substitute, no, so they're allowed up to 18 of these machines?
Mr. Chairman, yes, sir, that is correct, and that hasn't changed. We allowed them to expand that. Senator McPike, when did we allow them to do that? Last year or year before? Last year, if I remember correctly. So that has not changed. What has changed is where they can do it in those 18. They've basically been setting up these social quarters and defining them as they wanted to in bars and restaurants, when that wasn't the intent of the General Assembly.
Okay. Mr. Chairman. All right. Somebody have a question?
One question for the patron.
Yes, Senator Donovan.
In the notes that I have, wrapping my head around it, does the substitute resolve the concerns from the Fraternal Order of Police? Does the substitute resolve the concerns from the Fraternal Order of Police who are worried about it affecting charitable service organizations and them being able to compete?
Mr. Chairman, I would answer the Senator, yes, it does, because we specifically in the language talk about FOP, American Legion, and all those other various entities.
All right. Any other questions? All right. Senator McPike, you want to present your bill 1287?
Thank you, Mr. Chairman, members of the committee. 1287 is a subset of this and simply allows the existing electronic pull tab machines. It allows these charities to use a 2-screen device, and I do have, I believe it's either a substitute or a line amendment to make sure it clarifies that the 2 screens would only allow 1 player, so it's not a doubling of machines. So I think there's that also aligns with action that was taken in the House to help clarify that, Mr. Chairman. So I'd so move the substitute.
Mr. Chairman,
yes.
Just the bill that's on the screen is my bill.
Yeah, 8 and 7 are flipped. 78 and 87. So.
They're bad.
So.
Okay.
All right.
Thank you.
Is it a substitute or is it a line amendment?
If council can clarify that, I'm not sure if, let me see, I believe.
Mr. Chairman, it is a substitute. Unfortunately, the entire system is down right now. They're working on it. But the only difference between the original bill and the substitute is that there is a section, a current code section 18-340.28 that is added into the bill, and it adds a subsection D that says the use of electronic pull tab devices utilizing multiple video monitors or touch screens shall be limited to 1 player at a time. Otherwise, the bill is as introduced. And we're working to get that online as soon as possible. My apologies.
Okay, and is that basically where lines 43 and 44 were in the original bill?
Mr. Chairman, it would be at the very end of the bill, I believe, is where that
end of the bill
is added.
That is correct. Mr. Chairman, Senator McPike, yes, lines 43 and 44 was the original language in the bill. That is unchanged. There is an added code section that adds that new language. Okay,
all right. All right, want to make a motion
for the substitute?
For the substitute? All right, Senator McPike has offered a motion to adopt the substitute. Is there a second?
Second.
All in favor say aye. Aye. All opposed, no. All right. Are there any further questions of Senator McPike on the substitute for 1287? All right, thank you. Next is Senator Bell, who has 1278 and 1407, I think. He's hedging his bets. He has two bills on this subject, so.
Mr. Chairman, I'll try to be brief.
Okay.
1278 first. This actually clarifies, we passed a lot of bills last year, and there were a few things that were confusing. This actually clarifies Department of Agriculture and Consumer Services has specific authority to approve and regulate operators of both Texas Hold'em poker games and Texas Hold'em poker tournaments. The bill that was passed last year, when it gave the charitable gaming the ability to do Texas Hold'em poker, didn't really specify if it was just poker or if it was individual games as well. So this would specify that. In this bill, they would actually have the ability to do electronic poker tables, and they could actually do manual poker tables. The issue here is 2020 was a bad year for a lot of folks, and for the charitable gaming and industry, it was very bad. So the other issue they're facing is their population is aging, and many of them that play bingo are no longer able to play bingo. That was, again, with the COVID-19 was particularly bad year, but the charitable commitments they have are still there. So they're really looking for a way to grow and to replace what was there from bingo. I do know that there's opposition to this bill, and I can't tell you that we've made peace in the valley. I've tried my best. I think there's room to compromise on this, but we weren't able to get there through negotiations. The gaming community, I think, will be opposed to this. We did try to limit the number of tables and or possibly take out electronic, which I think those are good ways to make this more, put some guardrails on it. And there's some that see a threat to the casinos, and certainly I don't want to do anything to threaten the large investments and jobs that are being created. I do argue that there is I think a different clientele that would go to a VFW post versus to a casino for more full 360-degree entertainment. This is a very specific clientele, a lot of times with people who live in a neighborhood and can't go very far. So with that, I'll be happy to answer any questions that you or the committee might have.
All right. As I read the bill, it basically says that what was passed last year authorized Texas Hold'em poker tournaments, but did not have, was not explicit in some of the definition, et cetera, to allow Texas Hold'em poker games. And this would allow the games in addition to the tournaments.
Yes, Mr. Chairman.
All right. Are there any other questions for the patron?
Mr. Chairman?
Yes, Senator McPike.
I appreciate the discussion. I think one of the tenets last year that we struggled with in subcommittee and full committee was sort of the right balance of the different things. And we did put off a lot of things to charities last year. Some of the concerns I'm hearing is sort of on the electronic table side of it, which I think I do understand. And also, this doesn't seem to be as written necessarily the limit of the number of sort of tables. And so, just ask the patron, would, based on the balance of the last couple of years, would you be amenable to look at sort of a limitation of 3 table games and not electronic? So it'd be like 3 table games, I guess, and sort of strike the electronic game for this portion.
Mr. Chairman, I appreciate the suggestion, and I would be amenable to that. And I think that that's a fair way to put some guardrails and lower this down. When I did talk with the charitable gaming entities, one of the things they said is they thought a limit between 2 and 5 games would be fair. And I will tell you some of the facility, and that's per organization. I wouldn't say per facility. Some of them are so small they can't have more than 2 anyway. So I think 3 is a nice middle number, a good compromise. And I see the issues with the electronic, and I think taking that off is good. If the gentleman would so move, I would be happy to second.
Yeah, Mr. Chairman, I'd make those amendments to
Would relate to a limit of 3 games that would be operated with any organization, and that they would not include electric games.
Mr. Chair?
Yes.
I have a question before we go any further. Does this bill, does this address any of the issues that Senator Reeves' bill did as far as kind of the deployment of these games under the charitable, in quotation marks, name, but
You want to address that?
in name only?
Mr. Chairman, I'd certainly take that up. Certainly encompasses, on my bill, when you look at lines 118 through 124, we didn't change Texas Hold'em poker tournaments per se, but we did include them in the language where they have to come up with compliance so we can go in and if we need to audit them and their books so we have some oversight on them. The other thing that we required is that they have to be able to show proof that they've taken some of those proceeds, because we're leaving some discretion up to these boards, and that's a whole nother issue that we haven't talked about at some point my bill does not address. But we need to have that conversation in this committee about that. It's almost the fox watching the hen house, and I don't want to elaborate on that today. But I will tell you that we're going to mandate that these games as they're played show a certain portion of that actually going to a charity and not into manufacturers or those things. We're allowing them the autonomy to pay for some of those expenses and all that, but there's going to be a certain portion requirement in my bill that says they got to give it to charity.
Mr. Chairman, if I could add that as well.
Yes.
It does add some regulatory language. I would agree with Senator Reeves. I think we need to take a further deep dive on that, and I share some of his concerns. I will point you to lines 282 through 289, which goes into the application for licensing, and the department can choose not to grant. So if they see any problems, they can choose not to grant, and I think that is within the area that Senator Reeves is talking about.
Question really quickly.
Yes.
It talks about qualified organization. Is there a definition of qualified organization here?
Is your microphone on? I'm sorry, I'm having a hard time hearing you.
Apology. Can you hear me now? Is there a definition of qualified organization somewhere?
You know, I'm gonna ask the council. Is there in the code anywhere that?
Yes, there is.
I think there is. Yeah.
Lines 94 and 95 deal with qualified organization. And it says means any organization to which a valid permit has been issued by the department to conduct charitable gaming, or any organization that is exempt.
Yeah, I think that actually goes to several other code sections as well. Yeah.
Right.
Chairman, that's the same as mine.
Yep. Yeah, I think these bills will sort of overlap with things, and so in the end there will be consistency as it relates to what requirements are there and what enforcement is set up that Senator Reeves was talking about.
And Mr. Chairman, I don't know if this is doable or not, but I would not be opposed to, you know, combining these either, if that makes sense. I don't know if how different the code sections are, but
That's certainly doable. We'll pursue that maybe at some point here, so fairly quickly. So, all right. Any other questions of Senator Bell on 1278? All right. Then, if there's not, then Senate Bill 1407. That's your other one.
Yes, Mr. Chairman. This one's it's controversial as well. I'll tell you what I'm trying to achieve. This is I'm not a fan of the gray machines, and I'm trying to achieve a pathway off that. And this would replace the gaming with the gray machines with VGTs, which would be administered by the Virginia Lottery Board. I think one of the hard parts of the gray machines is many small convenience stores, businesses, truck stops, operators have become addicted to the income from that. And I know 2020 was a tough year for them, and this would be trying to find a way to regulate that. There would be a 34% tax on this, and the revenue projections on this are actually much bigger than the gray machines if we look at the historical performance in other areas. Now, I don't know if it would save the committee time or not, but there's a large fiscal impact. It would take money to invest this, and it would also take, according to the lottery folks, up to 50 FTEs. So it may be worthwhile to send this to finance because there's going to be a big decision made there on that.
Yeah, I think all of these will get referred to finance. I would. All right. We'll send that one there too, so just entertainment.
Mr. Chairman?
Yes, Senator Evan.
Just to clarify for me, because this is a big bill. I have 7-Elevens in my district that are having people sitting on stools and kind of gambling, and this would allow that to continue?
Mr. Chairman, it would. It would allow them to continue, though, with machines that are actually hooked up to a central repository with revenue reporting, and would also have a number of other safeguards that are not currently there on gray machines.
Thank you.
Mr. Chairman?
Yes,
If I could elaborate to Senator Evans' question to Senator Bell, we have machines that are out there from manufacturers that have no oversight, that are not charitable, and they have no oversight. I'm carrying a bill to catch all those. And because they're not paying any taxes, those are the ones giving the other guys that are trying to do it the right way, where we're getting the money and the governor tried to save them. And I know there's some in this chamber, this body, that don't like those machines, but they are doing what's right by the law. And then we have those that they don't care about the law, and I'm carrying a bill for that. So that, if that helps answer your question, I don't know what's being played at your 7-Eleven until we look at the machines, and it should have a tag on it if it's legit, and if it doesn't, it's probably a machine we don't know about because there's no oversight.
Yeah, Mr. Chairman, if I could, I'll try to be brief, but one of the issues with the gray machines is, I agree with what Senator Reeves said, and we've even found now there's these black machines that are in other illegal locations. And if we look at the reporting in other states, once there was some sort of central reporting, revenue doubled in a month. So I'm very concerned about the longer we keep them, the harder it's going to be to exit. So frankly, that's what I was looking for in this, is an exit ramp to try to, again, make whole these convenience stores. There's opposition from casino operators who view this as competition. There's opposition on this from the charitable gaming folks who, again, would view it as a threat as well. So I think we're going to have to work that out one way or the other, if not with this bill, with another mechanism. And if the committee were to decide not to move forward, I would ask for a letter from the chairman, because we really need to figure out how we're going to go forward on this.
All right.
So, Mr. Chairman?
Yes.
So it seems like the first three bills, maybe with the exception of Senator McPike, are trying to deal with the charitable gaming, outline who we want to have them, and then put parameters around what we're allowing and how much there. Is that correct? So it seems like the first three go together in some structure that we need to figure out how to move forward. But this one is separate and distinct. That is just kind of the new game versus the great game. And so is that what we're trying to do? Look at what we do with the first three, and this is entirely separate?
You are correct. That's an accurate assessment of what the bill will do. So.
And did the gentleman just say that if this doesn't move forward, he'd ask for a letter from you to the lottery or to whomever to determine what?
That's sort of how we deal with the residuals of the grave machines, basically, would be what it would be.
Thank you, sir.
All right. If there's no further discussion or questions right now.
Yeah, Mr. Chairman?
Yeah.
Yeah, I guess just follow-up comment. I appreciate Senator Bell putting this in, because I think if Senator Mason and others remember, the subcommittee that we spent extensive hours last year on really tried to deal with the question of the transparency of machines. If the primary question, if machines were going to exist, and then, as you recall, when the budget happened, it got passed through the COVID budget. And that was really not a policy question that this committee made. This committee had put forward a position of, if we're going to have something, we need transparency. And this is what the effort that Senator Bell is trying to put forward is. We want to ensure that this transparency to a system and regulated under the lottery. And I think that's, part of this alignment, and, appreciate it because that was a policy question that skipped over due to the adoption of the governor's budget. And so, this is an important discussion for this committee.
All right, let's do public testimony on all four of these bills combined, so that if there are people who want to comment, on any of these, that they can opine on their view of each of the bills that are before us. So why don't we just, since there may be people who are supporting some but not others, rather than just have everybody out, just have it all in one big mix there. So
Asking members who would like to comment in the affirmative or opposed to SB 1127, SB 1287, SB 1278, or SB 1407 to raise your hands.
Chris Peterson, please go ahead.
Chris Peterson.
Steve Barry, please go ahead.
Chris Peterson is I see him.
Mr. Chairman.
Yes, yes.
It's Chris Peterson, speaking on behalf of the Virginia Charitable Gaming Council. And as you can imagine, we have thoughts on several proposals.
Right.
First, to the 1127, we would ask this committee to pass this by and or to put it into study. There could be ways to improve the regulation of charitable gaming, but we are heavily regulated. And we can't get a machine in a charitable site unless it's been approved by the state. We can't do a variation of a game unless it's been approved by the state. So I think there is some misunderstanding on how we're regulated. We're fairly heavily regulated. So we would, and the changes are fairly new to us. We haven't really been able to absorb them all. So we would ask for ability to study them or to pass it by indefinitely, so we can look at these and consider this issue in a more robust setting. One difficulty of the virtual setting is many of these things might have been worked out around a table, but we can't sit around that table right now. So we are concerned about that. And I can say they had to get off, but the Fraternal Order of Police would also oppose 1127, the VFW, American Legion, and they might be here to speak, Elks Club as well. So there's several charitable organizations also with concerns about where 1127 is right now. And Senator Reeves has been a good friend of the veterans and charities, so we would like to work with him, and we think we have the opportunity we can. On 1278, this bill actually increases the regulation over Texas Hold'em. So I want to make people clearly understand that. The bill for the first time says the states can regulate operators. Right now, there is no regulation over operators, so we want to have the operators of these games regulated so bad actors don't come in. Right now, under regulation, electronic poker tables are allowed in Virginia. What we're asking and what we're doing is, this is at the request of the Virginia Charitable Gaming Board and VDAX, is to give the state the authority to review and approve those electronic game tables. So they're already allowed, so we're trying to get that authority to strengthen so that we know they're valid electronic poker tables. And the third thing is a clarification between games and tournaments, which came up during the drafting of the regulations on Texas Hold'em. Finally, I would like to also comment on 1407. We believe the games and bars and restaurants are a direct competition threat to the structure that we have in place. It's interesting to us that the new people to the gaming world, the casino, sports betting, all talk about the threat to their investment, and they use us as an example. But we were here first, and we have suffered a lot because of all the new gaming in the state. Charitable giving will be down 19 million in Virginia this year because of all this new competition. And we just don't think we can afford or can survive if we have additional competition through games and bars and restaurants. So thank you.
All right. Just a quick question. As I understand Senate Bill 1127, part of the motivation for that is that there are machines that are in some operations that are not authorized, and that's part of what
Yeah.
Senator Reeves is trying to get at there. So
I've heard that towards, late in this process. I've looked at it. It is my understanding that this was discussed, that location was discussed with the state and was viewed to be as permissible. So I think it's authorized, and that's why I think we need discussion. Whether it should be allowed in the future might be an issue for discussion. But I thought my understanding was that this was permissible in Virginia right now. So I think it's not that it's not regulated. It is regulated, and I think those machines all would have been reviewed by the state and approved by the state as well. And it would have been through a qualified organization. So I think it is regulated. So I don't think it's unregulated. I think it's regulated. The question is, which is why I think we need to look at this rather than pass legislation today, is whether that should be permitted.
all right. Any other questions for Mr. Peterson? All right. Next speaker.
Steve Barry, please go ahead.
Yes.
I think you may have meant Steve Burrell. If that's who you intended, then I'm Steve Burrell, and I represent the Virginia BGT Gaming Coalition. We were proud to represent them last year, and as Senator McPike mentioned, we carried a very similar bill, or he carried a very similar bill that passed this committee by a wide margin and was sent on to finance. When we got to finance, our bill was tabled because the decision was made by leadership there that they wanted to do first things first, which was to pass a bill that banned gray games effective last year, and that we were urged to come back with our bill so that we could try to provide a better alternative to what had sprouted up in the Commonwealth. So that's exactly why we're here, and we appreciate Senator Bell carrying Senate Bill 1407. It's actually, this bill is better. The stream of tax revenue to the Commonwealth is 34% more than last year. This bill also provides a substantial percentage to local governments that host our VGT games. The amount will exceed what they're receiving now under the enactment clause. And the other thing that I think Senator Bell and Senator McPike mentioned that's critically important is our games are altogether different. They are tested and they are regulated they will be by Virginia Lottery. The machines are guaranteed to perform at the level of expectation, which is an 85% payout. That's higher than the gray games, and that's the minimum. And they're certified to perform in that fashion. They provide the transparency that the Commonwealth deserves, which is they tie into a central computing system. So in real time, the tax department knows exactly how much play has been had and the amount of revenue that's been generated and exactly what the amount of money is owed to the Commonwealth. So we think we've got a superior product in the sense that we're generating more revenue. Our games are regulated. And the other thing I want to mention is, unlike the gray games that the Commonwealth has been dealing with, our expectation, and under this bill, this entire operation would be regulated the same as the casinos. Operators, distributors, hosts, they all have to be licensed. They have to undergo criminal background checks. we leave nothing to chance, nothing to trust. We're operating gaming devices, but you will have the assurance of exactly who you're dealing with and how much money is passing through these machines. So it offers the transparency that and the high quality that you're going to expect if you're going to go down the gaming road. So we think we've got a superior product. The other thing that we would urge you to consider is that the way things stand, gray games expire as of July 1. There isn't a bill pending before a committee to change that. And the governor has made a promise to leadership in both the House and the Senate that those games will expire. That would work a tremendous hardship on restaurants, C-stores, truck stops, and now local governments. And our goal is to make them our customers, and but to do it in a better way that's highly regulated and will satisfy the Commonwealth of Virginia. And as I said, to be repeated again, is the bill would allow Virginia Lottery to regulate this operation. So we hope that you will give this favorable consideration and report it out and refer it to Finance. Happy to answer any questions anyone may have.
All right, are there any questions? All right, who else do we have to speak?
Ken Wiseman, please go ahead.
Mr. Chairman, members of the committee, my name is Ken Wiseman. I represent the Veterans of Foreign Wars of the United States. And with regard to Senator Reeves, we normally enjoy working with him on many issues, but unfortunately this gaming bill is one place where we strongly disagree. Senator Reeves has put forth so many amendments related to this bill, and there have been numerous changes that it's been hard to track them. At one time, we identified that every single 501c19 veterans group would be removed from the ability to conduct charitable gaming in the Commonwealth. Now that's been fixed, but there are so many other issues. For instance, the lawful charitable gaming that we do, by the way, it's not VFWs that are in these bars and restaurants, but it's VFWs who will suffer under these changes. We would be limiting to conducting a charitable gaming to only 3 days a week. That's less bingo time than we had before Senator Barker's bill last year that gave us 7 days a week. It would also limit those social quarters that we lawfully operate inside our buildings to operating only 3 days a week of charitable gaming. And it would decimate the money that comes in. A lot of smaller VFWs that do not operate bingo use this money for their efforts. And during COVID, food security and economic security for our senior veterans was where we put that money. And this bill would decimate our ability to continue our efforts to do that. It also increases the audit fee on bingo and other things, which, by the way, are highly regulated, highly audited. We get reviewed every year. We have monthly, daily, quarterly, and annual reports, and to say otherwise is inaccurate. And to increase the fees again this year after already increased last year, when it's not even the agency getting all the money, is also something that we're strongly opposed to. If Senator Reeves wants to work with us, which, by the way, we didn't get a seat at the table, special interest did, we would be happy to have that conversation. But for the committee to believe that a $300 million casino could be decimated by a small VFW post is a farce. And to the point of Bill 1407 for VGTs, you're essentially trading one devil for another. The skill gaming could have been better managed, I will admit, but that's the fault of ABC. And that is something that we also review every month at the VFW. I have personally reported bad actors in skill gaming, and they were busted. And so if we're going to talk about gaming, which the VFW long supports regulated gaming, it should be regulated gaming for those that are there, not trade one actor for the next just because the percentage of revenue sounds better on paper. And so we stand opposed to the Golden Game Bill, another special interest. And let's be very clear, VGTs are
Mr. Chairman. Mr. Chairman.
I yield back, Mr. Chairman.
Mr. Chairman, can I ask that individual if he works for Powerhouse Gaming?
Mr. Chairman, I am properly registered as a lobbyist for both the VFW
Mr.
and
Chairman,
Powerhouse.
my question was, does he work for Powerhouse Gaming?
Mr. Chairman, I answered the question. I am properly registered and work for both the VFW and Powerhouse Gaming.
Thank you.
All right. Anybody else?
Irvin.
Mr. Chairman,
Yes.
my name is Sean Devlin. I am the past commander here last year of Braxton Perkins Post 25 American Legion down here in Newport News, Virginia. The American Legion is dedicated to serving the veterans and the community. We use legal and regulated charitable gaming to raise funds for many charitable programs. The American Legion strongly supports Senate Bill 1278 because it strengthens our state regulations over charitable poker. And I thank Senator Bell for introducing it, and thank Senator Bell for his many years as uniformed service of our country. However, over on to Senate Bill 1127, which Senator Reeves has presented, I am not employed with Powerhouse Gaming, just to make it perfectly clear. However, we are very heavily regulated down here at the American Legion, and all of our bills and everything that we do down here at the American Legion, at least at Post 25 American Legion, all right, we support our communities. And anything that takes away from our ability to raise funds to support our community is a problem, because then it reverts back to, if we can't support our community, then it has to fall back on the taxpayers of the state of Virginia. So we work very, very hard to support our community through our gaming efforts. And by further allowing this thing to go forward with 1127, we are so regulated now as it is, it's kind of unbelievable. But on Senate Bill 1407, we also oppose that bill because we strongly oppose that, because it brings slot machines to bars and restaurants. You talk about mom and pop organizations. No, they are, when you go out here and you see them, there are 7-Elevens. There's major corporations that are out there that are benefiting from that. And they're not putting money back to us, the charitable organizations that are supporting our community. So these machines would do even more damage to our charities and our lottery than unregulated skills games. I thank you, Mr. Chairman, for the time.
Thank you. Is there anyone else to testify?
Yes, Mr. Chair, we have 6 remaining speakers. Six remaining speakers.
All right. Who's next?
Barrett Hardiman, please go ahead.
Thank you, Mr. Chairman and members of the committee. My name is Barrett Hardiman, and I am here on behalf of Grover Gaming tonight. Grover is one of the manufacturers of the electronic pull tab machines that are used in the charities in Virginia. First, we want to thank Senator McPike for his Senate Bill 1287, which will allow us to modernize our machines in Virginia. Currently, we're only allowed to have 1 screen on our machines, and in most other markets, 2 screens are allowed. There was some concern as this bill was
upset over all this shit? You're damn right. Damn it.
Mr. Chairman, there was some concern around this bill as it was moving through that it would allow, with 2 screens, multiple players to play at 1 terminal at a time. That's why the substitute has a specific prohibition against that allowance. Additionally, the charitable gaming regulations prevent more than 1 game being played at a time on the machines. With regard to Senate Bill 1127, we do have some significant concerns about that bill. That was a pretty significant change within the substitute. Appreciate Senator Reeves' desire to take a very close look at the statutes and regulations overseeing the charitable gaming industry. But our hope would be that we would have the opportunity to work on that over the next year and have a robust dialogue about that. But look forward to that conversation with Senator Reeves, and thank him for that. Finally, Mr. Chairman, if I may just trespass for one more moment, Senate Bill 1407, certainly understand the reasoning behind that bill. Our biggest concern with that is that it does allow any other machine to be placed into a charity. The machines that we place in charities are very heavily regulated. When this statute was created years ago to allow electronic pull tab machines, it was very clear that the legislature didn't want anything that looked like a slot machine. And we're not allowed to have spinning reels, flashing lights, anything that attracts the player to the machine. So this is completely changing that policy direction. What we would ask is that the being allowed to place those machines in the charities be removed. Thank you, Mr. Chairman, and I'm happy to answer any questions.
Thank you. Next. Dylan Bishop, please go ahead.
Mr. Chairman, members of this distinguished body, my name is Dylan Bishop. I'm here representing Golden Entertainment and Accel Entertainment, among others. I'm asking you and the members of this committee to report favorably Senate Bill 1407. What the bill does is it offers a better alternative to the gray games, like my colleague Steve Burrell said earlier. On an apples to apples comparison with the same number of gaming terminals in the Commonwealth of Virginia, we anticipate that these machines would generate $186 million a year in tax revenue for the Commonwealth of Virginia, 48 million of which would be specifically allocated to the local governments in which these games are operating. This system also offers unfettered financial transparency. What we saw on the gray machines, specifically on the January 6th report, that ABC put out about the operations of gray machines in the month of November, showed that there were over 90 machines that were improperly reported. And but for the ABC's diligence, the Commonwealth of Virginia would have lost out on over $120,000 in tax revenue for that month as well. So that shows the inherent need for unfettered financial transparency. We also limit the number of games that would be permitted in the Commonwealth by location. In truck stops, it would be capped at 10 games. Right now, gray games are allowed up to 18, I believe. And ABC licensed restaurants and retailers, the number of games would be capped at 5, whereas they're at 8 now with gray machines. And we would also permit up to 5 of these terminals in charitable gaming houses. And what's different about our proposal is that the gaming operators in the host locations would be required to split the gaming revenues evenly. So that way we can ensure that small businesses or less sophisticated businesses do not get taken advantage of by these gaming operators. We also provide a local opt-out for communities that may have other interests, like a casino in the city of Bristol. The city of Bristol, by local ordinance, could opt out. The same runs true for localities that have historical horse racing operations, so on and so forth. These games would also have to be tested by a third-party entity to ensure that they are exactly what they say they are. And again, everything would be tracked in real time by Virginia Lottery.
Could you try to wrap up pretty quickly?
Yes, sir. Yes, sir. I'll conclude my remarks there. Again, this is just a more viable alternative, a better alternative for the citizens in the Commonwealth of Virginia. And I would urge the passage of Senate Bill 1407. Thank you, sir.
Scott Johnson, please go ahead.
Scott Johnson.
Good evening, Mr. Chairman. Scott Johnson. I represent HR Bristol, the casino that's being planned and developed for Bristol. Huge investment for jobs down there, huge investment for the community. We applaud Senator Reeves on Senate Bill 1127, making sure that everybody is operating in Virginia with guardrails. And certainly nothing against any VFW. We want every VFW to do well and succeed and do it right. But I think, as you heard from his first speaker in the question of Senator Reeves, sometimes you need to peel back a layer to see what you have. So we would ask that you support Senator Reeves' effort to bring everybody into alignment. And with that, I will conclude my remarks, given your short time.
All right, thank you.
John Garrett Kemper, please go ahead.
John Garrett Kemper.
Mr. Chairman, good evening, members of the committee. I want to just briefly walk you through some changes that have recently happened in this area. I represent the development group for the casino in Norfolk, and speaking really on behalf of all the casino operators as well. And why are we focused on this? Number one, well, the casino operators are about to make a $1.7 billion, that's hard money, investment in the state, creating over 7,000 permanent jobs. And so we need to understand what the regulatory environment is for all gaming. So when we looked at aspects of charitable gaming, and this is nothing against the good operators, the legitimate operators, but when we started to peel back the onion on this, as Mr. Johnson referenced, we found some stuff that was pretty hard to follow. And I want to just run you through some changes and then point out some parts of the bill that I think are different than what they've been explained. And this stuff is very complicated, and this deregulation of this industry has occurred through multiple bills where you don't really see what's happening until you put it all together. So just last year, charitable gaming was allowed on unlimited days. These are just the changes in 2020. Allowed on unlimited days. Prior law to that was 2 days a week. Charitable gaming was now allowed on unlimited games per day. The prior law was 2 sessions per day. And this is a big one, the third one. Charities could now host games as of last session. They could host games anywhere in the state. The prior law was you could only host games in the locality in which the charity was located or in an adjacent locality. And in the case of what Senator Reeves discovered in Fredericksburg, and I'm going to compliment him for really looking into this and working with us, Senator Bell as well. What he discovered there is those machines were being operated by a charity in Chesapeake. Those machines were registered to a charity in Chesapeake, the ones that he found in Fredericksburg. So that was a big change last year. Last year, the number of pull tab machines was doubled from 9 to 18. That's number of pull tab machines per facility, not per charity. There is no limit on the number of facilities a charity can operate in the state. And also, now that you can operate them anywhere, there's nothing that says a charity in Norfolk couldn't open up a series of 18 slot halls in Northern Virginia. So you don't see the picture until you string all the deregulation together. Also last year, new change to allow charities to conduct poker tournaments and poker games. We're talking about this tonight. That's not new. That was allowed last year. And I'll get to that bill in a second, but that was last year. Last year, you allowed a private company to operate these games. And it's true, this year, the bill allows regulation of those companies. There's no statutory limit on the number of games per week, a number of poker games per week, a number of poker games per day, the number of poker games per location. A Danville charity could operate unlimited poker games in Reston. And so when we look at this and we peel it back, there is a significant amount of issues here and problems. So who do you go to? Well, it's under the Virginia Department of Agriculture and Consumer Services. Who's the charitable gaming board? It's the charities. It's the people that operate the bingo halls. In many cases, it's the commercial operators that sit on the board. We just went through an extensive regulatory process on gaming, what we call front door process, where we came and asked permission and had a significant regulatory burden with minimum capital investments and a number of things placed on us. This is almost like the Wild West. And so we really do commend Senator Reeves for uncovering some of these loopholes, like charities can operate the games anywhere. With regard to Senator Bell's bill, it does provide for regulation of the charities' operation of the game, but you're going to have third-party charities, third-party operators, commercial operators potentially, operating poker tournaments anywhere in the state. So the casino operators would still oppose that bill because it expands something that we can't seem to find anyone who has a handle on how it works and how it's regulated. We support the changes in Senator Reeves' bill. We didn't initially support that bill, but we do now because it closes some of the loopholes. Number one, it closes the loophole that charity can operate games anywhere in the state rather than just in the community in which the charity operates. We heard a lot of testimony tonight about helping the community and my community. Well, that's not what these changes of last year did. They allowed commercialization across the state, well beyond the communities in which they were designed to serve. So this is not a predictable regulatory environment. I think it's a regulatory environment where the fox is watching the hen house. It also is a regulatory environment currently that is going to lend itself to a fair amount of bad behavior. And so with that, those are our concerns. We want to see the good operators thrive, but this has been a rapid deregulation that no one seems to fully understand. Thank you, Mr. Chairman.
All right. Anybody else? What's that?
We have 3 remaining speakers. Barrett Luria, please go ahead.
Mr. Chairman, members of the committee, Miles Luria on behalf of Colonial Downs. I'm also been allowed to speak for the Equine Alliance. Colonial Downs has invested thus far in the Commonwealth $300 million. We have over 1,000 employees. And Mr. Chairman, just want to associate myself with Mr. Kemper's remarks. Senator Reeves' bill begins to bring some rationality back to the charitable gaming space. We're very, very supportive of that bill. We do oppose Senator Bell's Senate Bill 1278 and Senate Bill 1407. Thank you, Mr. Chairman.
Thank you. Charles Jackson, please go ahead.
Thank you, Mr. Chairman. Charlie Jackson on behalf of Rush Street Gaming, Portsmouth's casino partner. We associate ourselves with Mr. Kemper's comments as well. In Rush Street, just for the committee's knowledge, plans a $300 million plus investment in Portsmouth with 1,300 permanent jobs, 1,400 jobs during construction. And I'd just like to make one comment related to Senator Bell's bill on VGT games. And Senator Bell, we do appreciate your work on this, but to Senator Ebbins' point about folks still being able to play these games in the 7-Elevens and the parlors in your district in Alexandria, Senator Eben, we would point out that there's no controls there. And so while there may be differences between gray games and VGT games, there's no controls like you'd have at a casino. There's no cameras, there's no security, there's no people looking out for problem gaming. And so for those reasons, we'd ask you to lay that bill on the table. Thank you so much.
All right, thank you.
Speaker Ann-Lee Kerr.
Good evening. I'm Ann-Lee Kerr, and I represent Caesars Entertainment. And the night is getting long, and I will make this quick. Just reiterate everything the previous speakers who have represented casino operators have said. We support 1127 from Senator Reeves, and we are opposed to the deregulation and the expansion of the gaming in the charitable area without some guardrails and some more careful thought. Thank you very much.
All right, we have now heard all the public testimony. The floor is open for discussion, for questions, and then for a motion, for a series of motions on the 4 bills.
Chairman?
Yes, Senator Boyce.
I just have a comment. I feel like this is really broad, complicated stuff. We have been here for a long time thinking through this. I'm very concerned that we're making very large decisions tonight. And I'm hopeful that we can find a way to continue this conversation into the future as opposed to making final decisions on broad policy for the Commonwealth.
Yes, Senator Boyce. So I think that actually what we have is we have 3 bills that are dealing basically with the charitable gaming end of the industry and everything, and that and all those 3 of those, if we report them, would need to be re-referred to finance. So there will be opportunity to help to continue the discussion on these types of things, and beyond this tonight, it won't go directly to the floor, it'll go to finance next week. And so we will have that opportunity, and there will be opportunity for those 3 patrons of those bills to move forward collectively and try to sort of make sure that everything is fitting together and moving in the right direction. So I think.
Thank you.
The other bill, which was Senator Bell's Bill 1407, is obviously a different situation, so then we can deal with that one differently, I think.
Mr. Chairman, if it's appropriate, unless there's more discussion, I have a motion on 1407, Senator Bell's bill. Would like to move to PBI that bill.
All right. Motion to PBI 1407. Is there a second to that motion?
Mr.
All right. Any further discussion on that?
Mr. Chairman, if I could have a letter from you, because this is something that needs studying.
Yeah.
Thank you, Mr. Chairman.
I agree, and if we do PBI, then I did assure to Senator Bell that we would send a letter to try to move forward with looking at the issue and figuring out where we go long term.
And Mr. Chairman, just to clarify, who would be the entity studying? Is this something that we should meet on in the interim, or a different organization?
I haven't discussed that in length
Okay.
with Senator Bell, but we'll figure that out. So. All right. With that, we can vote on the motion to PBI for 1407. Yes, yes, yes.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
Ayes 12, noes 2.
All right, ayes 12, noes 2. Okay, we will, so the PBI
Mr.
that
Chairman.
one. And we'll basically set up a process, write a letter to set up from the chair here, me, to set up a process to further examine the issues that have been raised and proposed with that bill. Now we have the other three bills.
Mr. Chairman, before we get into the process, if may I say something real quick? So I've known Senator Reed since before I got here, and I have never known him to do anything in detriment to a veteran or the military, including him chairing the Veteran and Military Caucus this morning at 8 a.m. So Mr. Devlin's a constituent of mine and runs a great VFW post. I think they just celebrated their 100th anniversary, and I just want to let him know that there's miles to go with these three bills that we're going to combine. And Senator Reeves has been looking at folks that were doing things that we didn't anticipate, nor did we lay out, and that I am certain that Senator Reeves has nothing but positive for VFWs in mind, and the activities they've been having, I'm certain we'll be able to work with them and help them along the way. So thank you, Mr. Chairman. I appreciate you letting me say that.
And I did see the 100 years on the screen.
Mr. Chairman,
Senator McPike.
I'd like to move Senate Bill 1127 report and re-refer to finance. I agree with the comments of Senator Mason. I think Senator Reeves has done a good job at pointing out some real gaps and issues that we need to start to figure out. And this bill still has weeks and weeks to go through the process to fine-tune along the way. And I'd like to see that process continue and not wait another year as these expand to different things under sort of false premise, Mr. Chairman.
All right, we have a motion. Is there a second? Second. All right. So we have a motion to report and re-refer to finance on Senate Bill 1127. We'll vote now.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
Ayes 14, noes 0.
Mr. Chairman, I move Senate Bill 1278 as amended to be reported and re-referred to finance.
Second.
Senate Bill 1178 is from Senator Bell to be reported and re-referred to finance. $1278, Senator Bell's bill.
We got rid of electronic and limited it to 3 things.
We'll vote on that.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
All right.
Chairman,
Senator Hashmi? Okay. Ayes 14, noes 0.
All right.
and Mr. Chairman, move report 1287. Substitute. Yeah.
And also refer to finance. So, that was not go to finance. That's right. That was the one that didn't go to finance. So, all right. So 1287, motion is to report, and we will open the board. So.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
Ayes 13, nays 0, 1 abstention.
All right. I think that does us for those 4 bills then. So it took a while, but I think it was very productive discussion and moved us in the right, good direction there on things. So next we'll have Senator McClellan. Did you bring your bingo card? So.
Yeah. Are they bringing cots?
We do.
Yeah. Do we have cots? Yeah.
Mr. Chair, I'm going to do what I think is the easy one first, because there's peace in the valley on Senate Bill 1327.
I'm not going to sleep without a glass of wine. Just saying.
I think there's a substitute.
Mr. Chairman, you should see that substitute on LIS now.
Okay, is there a second to the motion to adopt the substitute? All right, all in favor vote aye. Aye. All opposed no. All right, the substitute's before us.
All right, Mr. Chairman, this is a bill that we have worked very hard with the Virginia Poverty Law Center, the Virginia Bankers Association, the Virginia Mortgage Lenders Association, and the Virginia Association of Realtors to reach compromise on what we call the Preserving the American Dream Act. And this, as you know, homeownership is synonymous with the American dream, but there are many signs of a foreclosure crisis due to the COVID-19 pandemic. And in the interest of time, I will not go through all of the data points on that. But what this bill does now is make modest changes to Virginia's foreclosure law to help some homeowners facing foreclosure get the help they need to bring their mortgage current and protect their home. First, it requires a mortgage company to give a 60-day notice period to a homeowner of a pending foreclosure auction sale. Current law only requires a 14-day notice period. Second, it requires that notice to include information for the homeowner on potential legal assistance and housing counselors that may be available for assistance, which will make it
No, I can't.
and it will make it less likely for low-income homeowners that a vindictive creditor can force the sale of that person's home to satisfy a non-related medical, credit card, or other debt. Finally, it preserves the least cost entry into homeownership in Virginia manufactured homes by requiring localities to provide plans to maintain and improve manufactured homes, and ensuring that the residents of manufactured home communities are provided the same information about their rights and responsibilities as we have provided to tenants in apartments through the Tenant Bill of Rights bill passed, I think, in 2020, although I can't remember. And that's basically the bill. And with the substitute, as far as I'm aware, there's no opposition to the bill.
All right. Is there anyone to speak on this bill?
I know, I have one coming up.
If you would like to speak in support of the bill, please raise your hand.
Mr. Chairman.
Yes.
Senator McClellan, did you say the Poverty Law Center, the bankers, the mortgage lenders, and the realtors were all in support of the bill?
Yes.
That's good enough.
Did you work on vaccines next, ma'am?
We got that worked out, don't worry.
We do have to go through a public process here, so.
Mr. Chairman, I have one question.
Yes, Senator McClellan.
Do I understand with this amendment that the Virginia Manufacturer and Modular Home Association is also on board? Their opposition is gone?
I think so.
Madam Chair, Mr. Chair.
Yes.
I did receive, and to answer the senator's question, I did receive that they were on board, statement from them.
All right, do you have speakers? Okay, let's do 3 minutes for each side, so.
They've been waiting all day.
Chip Dix, are you in support of the bill?
I am.
Okay, you're our first speaker.
All right, thank you. Mr. Chairman and members of the committee, good evening. I'm Chip Dix. I'm speaking on behalf of realtors and the manufactured housing industry, and we do support the bill. Thank you.
Lauren Schmidt, please go ahead.
Good evening, Mr. Chair, members of the committee. Lauren Schmidt speaking on behalf of the Virginia Poverty Law Center. Senator McClellan did a great job of explaining the bill. This is a way to keep homeowners in their homes, and we appreciate all the stakeholders working together on this. Thank you.
Matt Brunning, please go ahead.
Mr. Chairman, members of the committee, Matt Brunning with the Virginia Bankers Association. Lenders don't make home loans with the expectation the borrower will not be able to repay their debt. Unfortunately, those do occur. It's important in those circumstances the process be efficient for borrowers to move forward and for the housing market to remain stable. This proposal strikes the appropriate balance of strengthening consumers' ability and time to fully understand the process and their options prior to a foreclosure sale without significantly complicating or unnecessarily extending the process to the detriment of the secured lender. We're pleased that much of the input the VBA provided throughout the process is incorporated in the substitute and acknowledgement of the productive negotiations with the stakeholders. We're pleased to support the bill and as presented.
David Albo, please go ahead.
Good evening. It's Dave Albo representing the mortgage bankers. I just wanted to say that the senator and the proponents of this bill got to us early. They listened. They took our suggestions, made fixes. In my opinion, this is exactly how bills should be passed, and we are proud to be a supporter of the bill.
Mariah Williams, please go ahead.
Good evening, Mr. Chairperson and members of the committee. I am Mariah Williams. I'm with Housing Opportunities Made Equal of Virginia, and we are here to support the bill. Just given the interest of time, I would like to say that our organization works closely and serves clients who are at risk for foreclosure. And in working with them, we've seen that, extended time of notice is really important in them being able to stay in their homes and just being given, the availability of resources. And so we are very excited to support this bill and would like to thank Senator McClellan for bringing it forward. So thank you.
Thank you. Anybody else?
Yes, Mr. Chair, we have one final speaker. Robert Bohannon, please go ahead.
Mr. Chairman, Rob Bohannon representing the Virginia Credit Union League. No position on the bill, but we appreciate the stakeholders reaching out to us, working with us, and addressing our concerns. Obviously, credit unions are very big on financial literacy and educating their members about these type of financial issues. Thank you.
Thank you. Is that it? They're all okay. Is anyone in opposition?
Against the bill, please raise your hand.
All right. All right. We got a motion to report. Does this need to go to finance? Okay. All right. Is there a second? All right. Motion and a second to report. We'll vote on the board.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
Ayes 14, no 0.
All right. That bill is passed. So.
All right, Mr. Chair. So the next one is the Senate Bill 1316. This was the workplace harassment bill. I would like to be able to say there's peace in the valley. We are close. I will tell you that the one remaining area of disagreement was there were some members of the business community that requested some clarification on liability issue, and the parties have been negotiating like up until the minute I walked in the door. They're close. They were close enough to say we can get this agreement out of this committee and then keep working as we go through either finance on the floor. Unfortunately, because they literally were in discussions up until the minute I walked into the door, we don't have time to do a substitute. So the bill is the same as you saw last week. There will be some amendments at some point between now and on the floor. Hopefully that our Peace in the Valley agreed to amendments that basically what we're trying to do is clarify the difference between what is defined as harassment, which is the first question, versus what is harassment that an employer can be liable for if it's not the employer directly doing it. And again, we are close, and all sides have my commitment that we will not leave the floor without either an agreement or at least a very clear, here are the two decisions that need to be made, and I'll make sure I whip those votes before we get to the floor.
Does this bill need to go to finance? It does. Okay, well, that will give us an opportunity then.
Yes.
Because that probably won't be till Tuesday that we'll be acting on this in Senate Finance. So,
yeah.
So we should be able to resolve this. So if anyone
Mr. Chairman, I'm comfortable with that.
All right, we have a motion to report and re-refer to finance, and we'll work on it as specified by the patron here. If there's no further discussion, we'll vote on the bill.
How do you vote?
Senator Vogel votes aye.
Ayes 10, noes 1, 3 abstentions.
Thank you, Mr. Chair.
Mr. Chairman,
Yes,
Mr. Chairman, could I ask the patron a question,
sure.
even though she may have already?
No,
And
she's
I'm
here.
here.
She's here.
With all the accolades that you got on the preceding bill, I don't think there's any more accolades that could be heaped on you. So my question is on this bill, the concern, I know there are many concerns and you're committed to work through them, but to the extent that there are some grave concerns, and these are the concerns I have, that is the exposure for employers for harassment that happens completely outside the workplace, this third party issue, this notion that it can happen with people that are employed there, but it has nothing to do with anything that happens in the workplace. I just want to be clear that when you're talking about getting peace in the valley, that you're committed to addressing that piece. Because to me, I would feel bad not abstaining if I didn't at least ask that question in this committee, that's something that you appreciate and acknowledge as an issue and are willing to work on before we get to the floor.
Yes, thank you for that question, Senator Vogel. That is exactly the issue that we are negotiating right now, because what we want to make sure is that, when I presented this bill to begin with, I said that essentially we were codifying what is already federal law. We are trying to make sure that we are doing that in a way that is not only clear, but addresses that concern and does not make our state law worse than federal law. So that we are, I believe, close, but we're not there yet.
Okay. Well, I just wanted to clarify, but if I may, Mr. Chair, my yes vote, I want to be supportive, but I also wanted to acknowledge that I have grave concerns about that piece and the enormous amount of exposure that we would be placing on employers were we to cast such a broad net that basically any workplace fraternization outside of the workplace could really be a grave issue for employers. So anyway, thank you, Mr. Chair.
And you will have yet your opportunity to address that when it comes to Finance Committee, so next week. So
I can hardly wait.
yes. All right. Thank you. Thank you, Senator McClellan. You don't have any more bills, no? Okay. Senator Donovan, Senate Bill 1183.
This will hopefully be very quick. There's no opposition that I know to this bill. This is a bill that's a response to COVID and HOA meetings trying to work out their issues. This does several things. It creates a definition of electronic means to modify and recognize meeting conducted by various methods. That's on line 36 and 37. On line 147 to 150, it introduces the option of voting by absentee ballot at annual or other membership meetings. This does not change quorum requirements that we've discussed before, I'll mention. On line 189 to 193, it eliminates the physical presence requirement of members of governing boards during meetings, which was another challenge. On line 240 to 242, if governing documents or condominium instruments require voting by secret ballot, you have to be able to provide secret ballot means. Line 249 to 254 establishes express authority to conduct association, governing board, and committee meetings electronically. And then 257 to 258 affirms that associations must make alternative means available to those members who do not want to conduct business with associations electronically. There are many groups that got together. We had Pia Trigiani on here earlier. I don't know if we still have anybody left on, but if the experts would probably do better with questions, but if there are no questions, we can just move ahead.
All right.
Really briefly, Mr. Chairman, a question.
It's here.
Just to be clear, the meeting is noticed like a regular meeting, and members of the association will have the opportunity to participate electronically. They won't be shut out.
Correct. The idea is not to replace any of the requirements that have been so debated over the years. It's just to provide another means of them congregating. And I know Pia can talk to that if you would like her to.
Just one final question.
Yes, sir.
Is the electronic meeting limited to circumstances that it's unlimited? It could happen at any.
It's a change in the POA and HOA guidelines that allows it to happen at any time and not just in the state of an emergency.
Thank you.
Mr. Chairman?
Yes.
My lines didn't add up. Is there a substitute? No?
Not to my knowledge.
Okay,
I think
thank you.
consensus was gained from the get-go.
Okay, thank you.
Yeah.
All right, are there any other questions? All right, if there are no other questions, does anyone want to make a motion?
Move to report.
Talk, she waited all day. Give her 30 seconds.
They're fighting over here. Who gets to make the motion to
I
report
know.
your bill?
That I love, guys. Bring it on, yes.
All right, we have a motion and a second to report the bill. Does it need to go to finance? Okay, I didn't think so. All right, just a straight report of the bill, so put it on the board. So
Thank you, Pia.
Thank you, Pia.
How do you vote?
You're welcome. Nice to see you all. Thank you.
Oh, yes, I'm voting yes.
Okay. Senator Donovan votes yes. Senator Vogel, how do you vote?
Senator Vogel votes yes.
Ayes 13, noes 1.
all right, next up, Senator Boysko.
Do we need to do anything about the stricken bill that we're going to pass over? Okay, I have two bills. One of them I would like to pass by for the day. Mr. Chair, I have two bills here. SB 1224, the Uniform Statewide Building Code. The group that asked me to carry it has requested that we pass it by because we can't get consensus.
All right, so this is to pass by for the day, which basically will end up. All right, all in favor of passing by for the day, say aye.
Aye.
All opposed, no. All right, we're taking care of that one.
Right. The second bill that I have is SB 1458. This bill would transfer the support and administration for the Identity Management Standards Advisory Council from the Virginia Information Technology Agent, or VITA, and the Office of the Secretary of Administration over to the Commonwealth of Virginia Innovation Partnership Authority, VIPA, and the Office of the Secretary of Commerce and Trade. The authorities, responsibilities, functions of the IMSAC will remain exactly the same. This legislation merely transfers the responsibility between agencies, and this is a request from the administration, and I move that we move the bill.
Second.
All right, is any public testimony on that one? I assume not.
Mr. Chairman, members of the committee, I'm the Director of Legal and Legislative Services at the Virginia IT Agency, VITA, here tonight to voice the agency's and administration's strong support for SB 1458. This bill will best align the Identity Management Standards Advisory Council in state government and position it for success going forward. Thank you for the opportunity to speak, and to Senator Boysko for carrying this bill.
All right. So we have a motion to report, and this does not need to be referred to finance, correct? All right. So we have a motion and a second to report the bill. If there's no further discussion, then we will vote on the board. So,
Vogel, how do you vote?
Senator Vogel votes aye.
Ayes 14, noes 0.
all right. Senator Pillion.
Thank you, Mr. Chairman. So this is just a conveyance bill. It authorizes the governor to lease a piece of property that was previously used by the Southwest Virginia Mental Health Institute in Smith County, but now a group called Appalachian Center for Hope, who are going to be working with substance use disorders for recovery and successful reentry in the community and residential care down in Southwest Virginia, is going to take this piece of property over if the governor will, if you so choose today, lease it from the governor for 3 years. This does need to go to finance, I believe. Yeah.
All right, is there anybody in the public who wishes to speak on this one? So,
John Graham,
John Graham.
please go ahead. John Graham.
He's going to be in favor of it.
Hi, this is John Graham. I'm the clerk of the Circuit Court in Smith County, Virginia, and I'm part of the Appalachian Center for Hope that's hoping that what has been the epicenter for substance abuse disorders might become the epicenter for substance abuse treatment. And we've got a lot of momentum and a lot of support from our regional legislators. I will mention that Senator Pillion has been a great advocate for this, but also Senator Chafin visited the building, and we had a vision for making Smith County really a hub for this activity for the drug treatment. And Senator Chafin encouraged us to think big. Why are you thinking so small? And I think that's an important thing to share with you all today, is that now our vision is to do this for all of Southwest Virginia. And this is a big piece of it.
Move to report and refer to finance.
Second.
all right, motion to report and refer to finance.
Thank you, John.
Mr. Chairman, I'd just like to thank that gentleman for what he just said about Senator Chafin.
Yeah. In fact, that day it was myself, Senator Chafin, Delegate O'Quinn, and Delegate Campbell all toured this facility with him, and there's 9 different localities in Southwest Virginia have come together to support this. So we're excited about it.
Yep. All right, put it up for a vote.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
Ayes 14, no 0.
All right, I think the last 2 bills we're going to deal with today are mine. Okay, you got another one there. Go ahead, Senator Bell. Who was the other one? Was there anybody else? Senator Bell? Oh, okay. Go ahead. Yeah, go ahead.
Can we sit down? Yeah, Mr. Chairman, Senate Bill 1418 is an administration bill request. The VEDP and others, took a look at obviously the impacts of COVID and realized that a lot of companies are not going to be coming and operating the same way. So this is a telework incentive, so an incentive bill that allows them the flexibility and authority to waive reduced capital investment to encourage drawing telework companies into Virginia. And that is the bill, Mr. Chairman. Happy to answer any questions.
All right, anybody have any questions? What's that? All right. All right, we have a motion to report and re-refer to finance. Put it up on the board. So.
Senator Vogel, how do you vote? Did she drop out? Okay. Ayes 12, no 0, 1 abstention.
All right. Senator Bell.
Thank you. Clerk, question for the clerk. Do you have the a substitute on this one?
Defer to staff on that question. Staff counsel.
Mr. Chairman, yes, I do have the substitute. I'm loading it to LIS right now.
Mr. Sorry, it's 1410.
All right, we have a motion and a second to adopt the substitute. All in favor, say aye. Aye. All opposed, no. All right, the substitute is before us.
Mr. Chairman, it's a fairly simple bill. What we found out is that there's actually there was some confusion in the code because there wasn't a definition when we talked about veterans, whether that included active duty or not. So basically what this bill does is it then defines military status and it includes active duty, retired, et cetera. So it just adds that. It's 38 pages long because it had to add it everywhere the code mentioned veterans before to make that match. We've had a few places where we've had veterans who were discriminated against, which obviously as a veteran, this is something I want to stand against, where they've been made to make higher deposits when they rent an apartment or house. And they've also been given a hard time because they kept their rapid deployment gear in their place of residence, which they were required to do for their duty. So this would put that in as a cause that they could then be protected in a discriminatory status. With that, Mr. Chair, I don't know if we have people on the line still or not.
Any questions of the patron?
Just to thank the patron. I think he's updated what we did last year, and I think it was needed. So thank you. Thank you for doing it, Senator.
Move to report the substitute.
Mr. Chair. Mr. Chair.
Me.
Mr. Chair, I just have a quick question. I'm not able to pull up the substitute and the amendments, and I just want to make sure that we have the right amendment. It is an amendment that I had introduced, a friendly amendment on line 982, that we agree to waive or forego the rights or remedies that are provided under the Service Members Civil Relief Act. This is designed to protect our military veterans from any kind of I'm sorry, I'm losing my train of thought, but designed to protect them under rental agreements so that they don't suffer and that they keep their the Service Members Civil Relief Act.
Mr. Chairman?
Yes.
To Senator Hashmi's question, if I may, that provision dealing with the Service Members Relief Act was in the original bill, but it is not in this version of the substitute. Is that what you're asking?
That's what I was asking, yes.
Okay.
And I would just ask the patron, is he comfortable with the new substitute language?
Mr. Chairman, I did work with the stakeholders, and that's why I took that out, because there was some disagreement on it. I'm here to fight for veterans, so of course anything that makes it friendly for veterans, but I don't want to go against the agreement I made with stakeholders. I will tell you there's different interpretations of that section, and but basically while the U.S. Code 50 allows the service member to waive their rights, there is different interpretations, whether some know what they're doing when they do that. I think Mr. Dix might actually be online, Chip Dix, to speak to that if he is in the queue. But
yes, he is. He is online.
So, Mr. Chairman, would you like me to address that?
Yes, please do.
Yes, sir. Mr. Chairman, members of the committee, so the U.S. Code in Section 3918 provides that the service member may waive any rights under the SCRA, the Service Member Civil Relief Act, and there's different interpretations of that federal law. Senator Bell's bill is addressing what rights military service members and veterans have in state law, and I believe that the senator's position is that he does not want to raise questions of federal law interpretation in this particular legislation. So that's the reason that he has discussed with stakeholders that provision would not be included in the substitute. But all the other provisions, I think all the stakeholders support.
Mr. Chairman, I would agree with Mr. Dix's statement, but of course the will of the committee.
All right. Senator Hashmi, do you have anything further on that issue? All right. Do we have people to testify here? All right. We have people to testify on this bill.
Clayton Medford, please go ahead.
Hi, Mr. Chair, members of the committee. Thanks for allowing me to speak today. My name is Clayton Medford, speaking on behalf of the Northern Virginia Chamber of Commerce. We have a very active Veterans and Military Business Council, and we strongly support the bill. Virginia has, as you all know, one of the highest concentrations of active duty military in the country, but also has the second highest concentration of military families who say they can't reliably afford to put food on the table. We believe these families have earned the right to the same economic opportunities as all Virginians, and ask that you report the bill. Thank you.
All right.
Brian Gordon, please go ahead.
Thank you very much, Mr. Chairman, members of the committee. Brian Gordon on behalf of the Virginia Apartment and Management Association and the Apartment and Office Building Association of Metropolitan Washington. We thank the Senator for working with us on this bill, and we are very happy to support.
Christy Mara, please go ahead.
Thank you, Mr. Chairman, and thank you, Senator Bell. We do support this bill overall, and really appreciate Senator Bell working with all of the stakeholders. I do want to let the committee know that when Senator Bell was speaking about different interpretations of the SCRA provision, it was, I'm with the Virginia Poverty Law Center. I may have forgotten that at this late hour. I apologize. But I do have a different interpretation of that than Mr. Dix. And so I don't know if, I didn't hear Senator Hashmi make any sort of motion, so I don't think there's an amendment to be for me to speak on at this point, but I just did want to let the members of the committee know that there is another position, and that is that there are a number of service members across the state who are asked to waive those rights under federal law known as the Service Member Civil Relief Act, and the original bill, not the substitute, but the original bill did have language that would make it unlawful for a lease to have a provision that required a service member to waive those federal protections. And so we certainly prefer the original version before that was taken out.
Mr. Chair.
Yes. Senator Hashmi.
Thank you, Mr. Chair, and I apologize. I know it's getting late, but I did want to offer that as a friendly amendment, and I would move the amendment to include the language of the Service Member Civil Relief Act. This would actually bring the bill into conformity with a similar bill that is working through the House, and we would be in agreement between both chambers. So I move the amendment.
All right. All right, there's a motion and a second to adopt the amendment dealing with the Civil Relief Act. Any discussion on that?
Mr. Chairman?
Yes.
Can I ask a question just to be sure that I'm clear on the amendment?
Yes, yes.
Senator Hashmi, you're interested in putting back in the provision dealing with the Service Member Civil Relief Act? Is that in addition to the code section that was added to the Senator Bell's substitute, or which was 55 on 1226, dealing with security deposits? Are you interested in switching them to go back to the original bill essentially, or to add in addition to?
Mr. Chairman.
Senator Bell. Yes.
Yeah, I appreciate, Senator Hashmi bringing this up. I mean, it does make the bill a little bit more friendly, but I did work with all the stakeholders. I did give them my word. I would ask, there's a version that includes that from the House. I would ask the committee to pass the bill the way I submitted it, and then if it's different with what comes out of the House, we'll go together in a conference and work it out then.
Mr. Chairman, I withdraw my friendly amendment.
All right. Okay, the amendment has been withdrawn then.
Mr. Chairman, I will renew my motion to pass the
I
substitute.
think we have one more speaker. Helen, do you want to speak?
Yes, sorry, Mr. Chair. Thanks for having me. I'm from the Attorney General's office. We support the bill.
Right. Okay, thank you. All right. Then we have a motion and a second to report the bill. Need to go to finance or not? Okay, not go to finance today. So, all right. We have a motion and a second. We'll vote on the board now.
Senator Vogel, how do you vote? Oh, that's ayes 13, no 0.
All right, 13-0. Now I guess we are down to the final two bills for tonight. Okay. All right, Senator Locke, I'm going to turn the chair over to you while I present the last two bills we'll deal with tonight. The first of those is Senate Bill 1365, which is dealing with the data system, shared data that we're developing in Virginia. As I think most of the people are familiar with, we did have legislation 3 years ago, I think it was, to try to integrate the data systems in Virginia so that they could communicate with each other and provide us with a lot of additional information that was helpful from a policy and an implementation standpoint. The state hired a chief data officer, Carlos Rivero, to be able to come in, and he's been working very hard ever since then and done a great job. Senator Donovan and I were appointed as members of an advisory group that was set up to move forward on things for the first couple of years, and then we wrote that they moved to a different structure, and now what is proposed is a Office of Data Governance and Analytics with a chief data officer and also in addition, a chief information officer there to be able to sort of work with all the agencies. Significant progress has been made in beginning to integrate data systems, but there's still a long ways to go. And a lot of the secretariats within Virginia have been working with the agencies within each of their secretariats to get them to move forward with this. What is proposed here is a data trust that would begin to move forward and can really provide some beneficial information, and actually which will then partly relate to the next bill that I have. And there will also be a Virginia Data Advisory Commission that will be set up that will have members of the General Assembly sitting on that as part of a 27-member group that is providing advice on the process there. Will be in the operation here is under the Secretary of Administration, and there are a number of agency and staff people who deal with data issues within the state government that are working collaboratively on a number of issues there to make sure that the systems are become more compatible over time and that there's interaction that can be held there.
Madam Chair, move to report.
So,
Madam Chair, before we report the bill,
Senator Reeves.
Senator Barker, can I bring your attention to line 182? It talks about members of this board. It says the Senate should have 2 and the House gets 3. Was that by design or compromise? Not trying to start something this late at night. I just was trying to ask because it's going to come up.
Yes, it will come up, and actually I had already caught that as well, so I got a copy of that and did provide the administration a little heads up that this might be an issue there, so that if I'll propose a motion to make it 3 and 3. So we will.
Mr. Chairman, I would make that motion.
All right.
Seconded that we move the membership of House and Senate members to 3 and 3. All in favor of that, please say aye.
Aye.
Those opposed? Okay.
Madam Chairman, I have one question.
Mr. Donovan.
One comment and one question. I find it ironic that they want more members when they never appointed anybody to the work group.
I don't think they wanted more members, but I understand the point precisely.
However, this cobbled together in a lot of different ways, and it came together at a particular time where there were studies and investments that were being made by some of the agencies that rolled into the data trust and how we were looking at problems like the opiate crisis, which was the first charge we gave data analytics when we set it up. But with that, there has been a lot of questions about procurement, because procurement has not been typical because of the way I think it was cobbled together. And going forward, we want to make sure that they are compliant with the Procurement Act, so that there's competition and opportunity for innovation. Could you comment on that, Madam Chairman? Could the patron comment on that? Maybe tell us a little bit about making sure this is a competitive opportunity.
Yeah, I think it's dealing with it as it relates to the interfacing of the data systems, but also to ongoing purchases within each agency. Part of the problem that we were encountering when we first got started on this, and Senator Dunlap and I were on the board there, advisory board that was set up initially, what we had was a situation where each agency was doing its own procurement process, and there was nothing in the procurement standards or the requirements that dealt with compatibility of the systems with other systems in state government, even in related agencies, even under the same secretary's office. So I think there's an opportunity to have this push in that direction, but also make sure that we have a strong competitive system for acquiring equipment and technology thing, so that for the integration of it as well. So I think it's both the agencies themselves, but in addition to the integration.
Perfect. Thank you, Madam Chairman. I just don't want us to forget and repeat some of the same mistakes we've made in the past that were very expensive.
Yeah. And what we have is I've talked with Carlos Rivero, the Chief Data Officer, and he says he's not making any direct purchases of equipment within the next year, but we'll be looking at integrating some things and coming out with proposals on data equipment beyond that time period.
Okay. Okay. It's been moved and seconded that Senate Bill 1365 be reported and re-referred to Finance. Is there any further discussion? Okay, so we will vote on Senate Bill 1365.
Ayes 13, noes 0.
Ayes 13, noes 0. That bill is reported and re-referred. Okay, our next bill.
All right, the last bill is Senate Bill 1469. This is a bill that was just dropped the other day. Was a bill I was asked to carry this by the Attorney General's office. This is dealing with opioid abatement, creating an opioid abatement authority. So it would create, in essence, a public body that would be dealing with the issues related to the opioid crisis that we have. And what is anticipated is that that Virginia, as well as many other states across the country, if not all states, are likely to be getting significant sums of money as a result of settlements that are being negotiated right now to provide, that will provide millions of dollars for people who were guilty in one form or another, at least from a civil standpoint, in terms of pushing use of opioids in ways that resulted in a lot of the problems that we've had ever since that time. And so what is being done now is to try to set up an authority that would be the repository of those funds and it would make decisions in terms of how to implement them. So it would not be too dissimilar from the Tobacco Commission and a couple others that have been set up along that line. So the bill has been drafted and everything. There are a couple questions that have come up on some things. One was that whereas there are going to be legislative members that, as part of the data trust, there are no legislators that are proposed to be part of the governing body here. So that is an issue that we'll have to take a look at there. And certainly I've talked with Senator Pillion, who clearly has a strong interest in that, given some of the issues in his part of the Commonwealth. So there are a few issues. A couple of people have suggested some amendments on things. What I think would make more sense is, rather than trying to look at and debate significantly some of these potential issues where we might make amendments, is to let this bill go forward to the Finance Committee and then deal with those issues there and on the floor to try to move it in the right direction and be comprehensive on things. And,
okay. It's been moved and properly seconded that Senate Bill 1469 be reported and re-referred to Finance. Is there further discussion?
Madam Chairman, I think there's a consensus belief that it should be 3 and 3, Senate and House, if I may propose that amendment, knowing you're going to amend everything else upstairs.
Second.
Okay.
So we'll take that amendment now.
We'll
Do it up there?
Yeah.
Okay.
So
Yep.
we can,
Yeah.
so we'll do it there.
Yeah, we can do it there. So we'll take all those. So we'll deal with the amendments at that time there. So.
No, we're gonna amend it.
After it goes up to.
So the motion is to report and re-refer to Finance.
Yeah.
No amendments.
No amendment.
No.
No amendment this time.
So again, the motion is to report and re-refer to Finance. Any further discussion? Okay, so please vote.
Ayes 13, no 0.
All right, we have one bill that has not been addressed. That's a bill from Senator Deeds. So what I probably will do is just do a quick committee meeting at the chair's desk, or at the chair's box. That's right. Yeah. Yeah. All right, thank you all. It took a while, but we did a good job. Yeah, I know you're doing the right thing. Oh, yes, we're adjourned. At 8:59, we made it before 9 o'clock, so.
Enjoy night at the museum.